representing the amount of dues. Therefore, this court in this writ in this intra-court appeal would sustain the observation of the learned single judge that there has been violation of requirement as envisaged to be carried out by the employer under sections 25F and 25G of the Industrial Disputes Act. However, we have considering the fact that the respondent was in effective service only for about 4 years and 8 months in total, and out of service since 1989 till 2010, and subsequently since 2011, and no scrap of paper has been furnished to this court to show that she was not in gainful employment during the said periods. This court deems it appropriate that the direction of the learned single judge at paragraph 14 of the impugned judgment requires modification. Therefore, the appellants are now required to pay lump sum monetary compensation to the tune of rupees 2 lakhs. This court accordingly directs payment of lump sum compensation of 2 lakhs to the respondent within a period of 8 weeks from today, failing which said amount shall carry interest at the rate of 6% per annum till actual payment. In the result, the judgment dated 17/8/2021 of the learned single judge in WPCOAC number 3077 of 2014 stands modified to the extent indicated above, but in the circumstances there shall be no order as to costs.
I agree.
Obliged.
Item number 2, W82265 of 2023.
The amendment order 2008 recognizes office peon, signs attendant and watchman come sweeper under the one category, namely peon. Therefore, the question of assigning of seniority arises only in relation to employees who are similarly situated, that is, where they are functioning in the same rank, grade, or cadre. This is because seniority is a comparative or relative concept. Pondering thus, it is safe to say that there is no illegality committed by the learned single judge in holding that the authority concerned is competent to rectify the mistake committed in assigning seniority on the basis of dates of entry into service by the respondent number 6 and the appellant. In the result, having found no manifest error in the judgment of the learned single judge warranting interference, the writ appeal sans merit is liable to be dismissed. In the result, the writ petition is dismissed, but in the circumstances, there shall be no order as to costs. Writ appeal is
I agree. Item number 3, W587 of 2024.
the writ appeal stands dismissed, but in the circumstances, there shall be no order as to costs.
I agree. Yes.
Lordship permit me, Lordship kindly permit me to be mentioned. Should be listed the top. Otherwise, what is the item number? You mentioned. No, no, one matter funded by the Supreme Court with an observation that should be heard as gravity. There are two such cases. Mission Lordship, in fact, Lordship is a constituted bench, independent bench, Lordship.
Now
Okay.
the list has been called.
Sorry, Lordship, but
Yes.
okay, Lordship is a constituted PIL bench to only consider the Cuttack Lordship affairs, Lordship, and one public interest litigation regarding the protection of the reservoir, Lordship of 2019. It is also pertinent to Cuttack. Only a brave Lordship with bench is functioning tomorrow. This matter may be tagged to that bench so that Lordship in similar issue all can be.
That purpose of that bench is very limited.
It is also as like the same the drainage facility, Lordship. This is protection of the reservoir, Lordship. Jalasaya.
Reservoir is different.
Then-
Reservoir, no,
Then
that
Lordship can fix only
is
fix
for-
any date, Lordship, so that
that can be seen.
Lordship.
That matter is for a different.
Ajay Lordship,
limited
please.
purpose.
Ajay Lordship, please, Lordship.
I beg pardon, my lord, may I mention?
No, don't.
Item number 4.
Don't give slip, mister. Why are you giving a slip?
Sorry, Lordship, because
We have
I thought,
rejected your, that cannot be listed with that matter.
no, Lordship, I am thinking any date, Lordship, so that this because we are appearing in this case also urgency there because now Lordship the persons are
Make
engaged.
a mention tomorrow.
Lordship, that Lordship.
Cess admission item number 4.
Lord, yesterday the matter was on my Lord's board. That is the primary elementary education matter. I was supposed to give a chart indicating the deficiencies to be
Yeah.
uploaded. In fact, I have prepared it.
So we will take up this matter again tomorrow.
Right, Lord. I
Right.
have also served a copy on my
Yes.
learned friend. Let him.
So they may talk to the officials that this is the tabular chart which is going to be part of a judicial order. All right. So they may improve it further. Day after tomorrow, yes, we can take up.
After tomorrow is 17, no?
17 we can take up within first 5 cases. So you may improve it further because that is based on his experience or
Right.
whatever based on the present litigation also. So you can improve it. All right. Because this is going to be a part of a judicial order.
Lordship
be-
is proposing some.
No.
I'm so sorry. There are two parts that I have given.
Hmm.
One is basic amenities, other is literacy and dropout rate. How to control that and how to admit those students who have not taken admission in schools and moving around.
They must be having data, but
They have to be admitted.
all right. And that will help the department also, the government also.
Correct.
Senior counsel appearing as amicus curiae has produced before us format, 2 formats. One regarding availability of basic amenities in the schools imparting elementary education in this state. And the other regarding admission and dropouts, admissions and dropouts in the schools in Odisha. Stop. We propose to direct the concerned opposite parties in the state of Odisha to make available certain information in the public domain, and the said formats have been prepared to assist this court for passing appropriate orders to be followed by the opposite party in relation to the status of elementary education in the state. Stop. A copy of the said draft formats have been served upon learned AGA representing the state of Odisha. Stop. List this matter on Thursday within first 5 cases. Stop. First 5 cases. Friday. First 5 cases, so as to enable learned counsel, learned AGA to seek instructions as to whether the instructions from the opposite parties as to whether the format so prepared can be further improved.
One just a typographic error in a, I may take liberty to correct it. One just typographic error in a word is there. I'm grateful, Lord.
All right.
Say.
So that
Today also I am wrong.
no, no, no.
I'm just doing it, Lord. Yes. Manoj, এটা ঠিক করো পোর্টেবলটা POR জায়গায় POTABL. I'm grateful, Lord. Column 10. It will also greatly help me because I'll be not required to travel to the nook and corner of the state. If this comes out in the public domain, every information is available.
No, and whatever information is available, that can be verified also
Yes. Correct.
easily by, say, we have paralegal volunteers,
Yes,
we have legal service, presence of legal service authority
Right. Lord.
everywhere in the
Otherwise,
state.
what is happening is to pick up a school, to go to a district, find out that what is there.
It is impossible.
It is impossible. So once this is there, it will be easier to make a sample survey and come back to my lords. That will be so grateful, madam.
And that will keep them also alert.
Updated,
Alert.
alert.
Yes.
Submission item number 5.
This item to pass on.
Why, madam?
My
As
senior
requested on
engaged
behalf
in
of the
another court.
appellant list this matter after vacation.
Item number 6.
Item number 6, Lordship, the contemporary is not complete the order, my lord.
May I submit on behalf of Mr. Samantre, my lord. Well, in this matter, it's a land acquisition matter by the Ames Bhubaneswar, my lord. The collector was directed to assess the compensation. My lord, he has communicated to us that he has written a letter to the Ames director. They have not communicated regarding the land acquisition details, my lord. So that is why he is unable to.
Let us see the order first.
Yes, order is at page.
Page 7, Lordship. 9, Lordship.
Page 7, my lord, and the operative person, page 9. my lord. Sorry.
So the letter was already given to you on 9th March 2000, dated 9th March 2023. The collector had to make assessment.
My lord, pursuant to your lordship's direction, 15/5/2023, the collector has called for the documents, which is there in the instruction, my lord. The next page. And what he has called for, my lord, that is attachment is there. These are the things that he has called for, and he is there to receive these informations.
Then we are initiating contempt proceeding.
My lord, your lordship, can I pray for my lord, because the director is not a party here, my lord. That is-
You will plead director as a party.
Lordship.
Learned counsel for the petitioner is permitted to implead the who is the
My lord, director of aims.
He was OP number 5 in the writ petition, my lords. But his name, he has to be.
permitted to implead the director, All India Institute of Medical Sciences, Bhubaneswar,
Yes,
Yes.
Bhubaneswar.
Bhubaneswar, in his individual capacity as, what do you call, opposite party or what?
Contempt.
As,
Opposite party.
He's not a contemner. He has not been, he is contemner.
as, what do you call, contender, opposite party or what? Opposite party number 2. In course of the opposite party number 2 within a week. Did the by. This matter on 1 week. Oh, after vacation, we'll see.
Lordship, 1 year past, Lordship, he is not compliant.
What can be done? You have not impleaded him as a party.
Lordship, this honorable court single judge directed to do the opposite party number 2
Honorable
collector,
court's
Lordship.
order we have seen. Now the question is the non-compliance. The collector has expressing his inability because Director IMS has not responded. And you have not impleaded Director IMS. Director IMS was party in the writ proceeding. Was he a party?
Yes, he was.
Yes,
OP
Lordship.
number 5.
OP number 5,
So
Lordship.
you should have impleaded.
He was called person.
Yes, his personal appearance was also direct. So let it come after vacation. We'll see.
Executive director.
Huh?
You will say executive director because he
My lord,
came.
No, we don't know, in fact, who has violated. We have directed his, he will have to be impleaded in his individual capacity. So he will have to give his name of the director. Then we can see.
In para 3, it is. He says to take.
Because number of documents have been called for. Unless they are there, my lord, the collector has attached a
Let the
number.
director-
Yes, ma'am.
Item number 7.
Obvious, my lord.
Alright, kindly turn to annexure 1 at page 34. At the top right hand corner,
Hmm?
you let me see the date 28/7/2012.
Are you challenging an order?
Yes, ma'am.
Which is that order?
That is that order you will find at page 62. But this is the prayer para 3. My prayer is quoted. My ground is the annexure 1 which I showed that was initiated way back in 2012 and retired from services in 2017. So after the retirement, the disciplinary proceedings so initiated stood lapsed because there is no enabling provision in the Staff Services Rule 1980. And relied upon 2 decisions of the Honorable Apex Court also, one of which is also relating to cooperative society institution. My lord, kindly turn to para 4, the factual position.
Cooperative society is actually. Who are you?
My lord, I am a retired employee of the opposite party bank, respondent bank.
Retired employee of?
Orissa State Cooperative Bank.
Then what is wrong in the opinion?
My lord, according to me, there is no enabling provision in the staff service rule to continue the disciplinary proceeding after my retirement. There is no, just like the Orissa pension rules
So
or
you
civil
can
service
go to
pension.
the tribunal and tell the tribunal. You could have gone to the tribunal and you could have told the tribunal.
Just your lordship sees the 67B,
Yes.
powers of the tribunal. Notwithstanding anything contained in any law for the time being imposed, any disputing arising in connection to election of any officer bearer of a society or the disciplinary action taken by the society or its committee against any paid servant.
Yes. So
But
you are not paid servant.
I am not a paid servant. That is the limited contention. If he holds the retired employee is a paid servant,
Yes.
then I don't have any case.
So you was a paid servant.
No, my lord, I am retired. It is not a pensionable establishment.
What was the dispute about?
Dispute regarding the lapsing of the disciplinary proceeding.
Therefore, that was lapsing of disciplinary proceeding because you were paid servant.
Paid servant till I was 2017. After 2017, the employer-employer relationship snapped. Thereafter, there is no provision, just like pension rules, for continuous disciplinary proceeding after retirement. In case of government establishment or in civil services establishment. So therefore, the paid servant doesn't include a retired employee. Otherwise, the transfer condition of service, everything would have been included by the statute. But that is not so. As on date, there is no dispute case before the London Tribunal where the retired employees are, the cases of the retired employees are entertained.
Oh. There you go. You can hold it. It is covered by section 667. This is indisputably, the appellant was paid servant of which society?
Orissa State Cooperative Bank.
Odisha State Cooperative Bank. When a disciplinary proceeding was initiated against him
Way back in 2012.
in 2012. Started in 2012.
Started in 2012, didn't continue at all.
All right.
Yes.
Started in 2000. When did you retire?
36, 2017.
He attained the age of superannuation on
6 June.
36 2017. Oh, stop. With a plea that as master-servant relationship between the bank and the appellant ceased consequent upon superannuation, where did you go?
No, I retired from services, madam.
when did you file writ petition? After 6 years?
No. Once I filed the writ application, that was remanded to consider my representation. They rejected it. Again, challenge. Ultimately, this one could held that it not maintainable because I have.
It is the petitioner's case that there is no provision for continuance of a departmental proceeding after his retirement under which
Staff Services Rules 1980.
under the Staff Services Rules 1980 of the bank
Of the bank.
of so and so bank. Full stop. The petitioner, the appellant, had earlier approached this court, whereafter the matter was remanded back to the bank,
Yeah, to the authority, to the managing director.
to the authority, to the managing director of the bank. Full stop. What is this order? 14/2/2023?
14 to the rejected matter.
The managing director of the bank rejected the appellant's contention that the disciplinary proceeding lapsed with his superannuation. This is the order.
No, this is not the order. She didn't touch it, this aspect. But she says managing director has no authority to drop the proceeding.
All right. On the appellant claim by an order dated 14/2/2023 with a finding that he did not have the jurisdiction to drop the departmental proceeding. So stop. Assailing the said order dated 14/2/2023 and seeking a declaration that the disciplinary proceeding initiated on 28/7/2012 could not continue after his superannuation, the appellant filed a writ petition before this court, giving rise to WPC number 13454 of 2023. Full stop. A learned single judge of this court has disposed of the said writ petition, taking into account the provision under section 67 capital B of the Odisha Cooperative Societies Act, 1962, and has granted the appellant liberty to approach the tribunal by filing an appropriate application, if he had any grievance against continuance of the disciplinary proceeding. Full stop. The said order of the learned single judge dated 12/3/2024 is being assailed in the present intra-court appeal. Full stop. Learned counsel appearing on behalf of the petitioner appellant has argued that the learned single judge has misconstrued the provision under section 67 capital B of the Act, which refers to only paid servants of the society. paid servants of a cooperative society. Full stop. Since the appellant is no more a paid servant of the cooperative society after his superannuation and after he attained the age of superannuation and his service is not pensionable, comma, section 67, capital B of the Act shall not apply. So stop. Section 67, capital B of the Act reads as under section 67, B bracketed 1. Reads as under B11. Full stop. Next. We do not find any infirmity in the reasoning assigned by the learned single judge while interpreting the provision under section 67B, capital 1, section 67B1, bracketed Roman 1. So stop. Admittedly, the departmental proceeding was initiated against the appellant when he was a paid servant of the society. Stop. Dropping of the disciplinary proceeding consequent upon his superannuation, whether the disciplinary proceeding could be said to have lapsed upon his superannuation or not, comma, in our opinion, comma, falls within the tribunal's jurisdiction to decide under section 67 capital B of the Act. Full stop. Merely because the petitioner, the appellant, retired. You have not retired.
Yes, retired.
You attained the age of superannuation.
Way back in 17.
Okay. Appellant attained the age of superannuation, comma, he his status, comma, for the purpose of invoking section 67B of the Act as a paid servant of the cooperative society does not diminish. So stop. Next, accordingly, we do not find any merit in this appeal. This appeal stands dismissed.
But for a moment, you let me kindly see page 80. Page 80, employee, in the services rules, staff services, the word employee has been defined. Employee means a person employed by the bank. Meaning thereby, when a paid servant is paid something, a salary or discharge for discharge of duty. A retired employee is not part of the structure or the system of the cooperative society.
That we understand. That we understand. We have this thing interpreted section 67B. So whether that is attracted in your case or not.
Yes.
That is the question. That appears to be correct. You can go there, you will have same thing.
But the
Such
problem,
matters we
problem
should
would
not
be, all the retired employees would be now available to the 67P.
Yes, yes.
Which the.
Don't know. Don't know. Let an employee come, we will decide his case also. See, you are dealing with your case.
Yes.
You are not dealing with the case of others. What will they do? What will they not do? We don't know.
That's correct, ma'am. Only
Right.
little prayer may I have. The times granted by the Honorable Single Judge stood lapsed.
While dismissing the appellant's writ petition, while disposing of the appellant's writ petition by the impugned order, the single judge had granted the petitioner liberty to approach the tribunal within 3 weeks from the date of the disposal of the writ petition, from the date of disposal. Full stop. In the facts and circumstances of the case, the said order is modified to the extent that the petitioner appellant shall be at liberty to approach the tribunal by filing an appropriate application within 3 weeks from today.
Timeline for disposal.
Timeline is not. We, since the matter is, since the dispute as to whether the disciplinary proceedings should continue or not is pending since long, we direct that if such application is filed by the petitioner within the aforesaid period, the tribunal shall adjudicate the same as expeditiously as possible within a period of 4 months, as was given.
Deep.
4 months from the date of such file.
Item number 8.
Lordships, I happen to go through that judgment and I think though there is some hope, but as far as the facts are concerned, they quite stand distinctly. So I'm not insisting on that judgment, Your Lordships. But however, this is a fact that exams were happening. And probably, I think it is the college or the institution, if noticed, can give a better picture. And then maybe the applicability of that 1983 circular would become clear. Only if the college is noticed.
Just what is the matter about?
Your Lordships, that matter yesterday, which we.
Still,
Director has
Yes,
power,
yes.
power for appeal.
But whether the remand and director hearing that matter
It's not recognized or aided.
at that point.
oh yes,
Yes, at that point it wasn't recognized. But they had they were going through their exams.
Mr. You have been doing many education matters. Appraise this court whether such type of institutions were ever going to director for adjudication.
Strictly on the basis of instruction matter, appeal was not maintained, but director being the highest authority, definitely a person agreed to approach the director. But this is my submission. A school not recognized an employee such termination, he can approach the director.
How?
The director is the highest authority.
Oh, the director may be the highest authority. If some dispute is there in the family, so can he go to the chief secretary? Because chief secretary is the.
My suggestion, but there is no appeal. No appeal. As such, there is no.
The only issue is because
I
the
was,
exams.
I was answering my query because the person of that institute cannot go without, there has to be some protection.
No, he cannot, see, if a domestic servant has some problem. All right, so he has a remedy. He can go there. But he cannot go to the Director of Education or the Home Secretary.
Has been followed, there is no law, there is no rule, but they have been following it.
Then
They
we
have been
shall,
following it.
then we should lay down.
But there's one thing, Your Lordships, all the parties participated there and there was a fact finding. So that's one thing which is this year that way. There is a fact in my favor. So they did find me that, yes, I was working and I should have been allowed to work. That's the only thing. And the college also participated.
Everything was quorum non juris. They did not have. Such disputes. So you are citing any decision or something?
No, Your Lordship, I've gone through that decision. I myself is factually found it different. So I'm not insisting on it.
All right, we will pass order tomorrow. Because we may lay down that in case purely privately managed institution not having any recognition or affiliation under any statutory provision, such disputes cannot go to the director. In one of the judgments, I was seeing that the recognition granted today was given retrospective effect. I have my doubts. Still.
That,
To-
there are judgments it cannot be. But in some of the, I am also aware, in some of the, one of the High Court has granted.
Recently, I saw one order, but yes. Tomorrow we will pass on.
Lordships.
All right. Because we will say that. Say that. Did we test it? Wider impact. And these are aspects will be tested also at, see if someone.
Item 9.
Item 9, Your Lordships, may I take Your Lordships to page number 21, which is the single bench order under challenge.
Yes.
May I give a brief background, Your Lordships? Here is a person who was appointed as a lecturer, and then he goes to become the vice principal, and there was acting principal. And that's the point when a suspension was issued against him, and so also a charge memo. He comes and challenges both the suspension and charge memo on the ground that it's not issued by the competent authority. The court then, and the issue being that the governing body had not been formed according to the rules. And then the court also makes an inquiry from the department and finds that, yes, the governing body has not been constituted. And therefore finds that, yes, the suspension is bad and it's obviously without jurisdiction. There's one of the arguments which the government side made was that if that is the logic, then he could not have been promoted, neither been appointed, neither been a vice principal. So what the court did while passing the order in my favor said, no, you will join back and be demoted back to what you were on 24 years back. So I'm a due retirement 1 year.
So you got judgment in your favor. Your submission was accepted in toto.
Lordships, that really wasn't my submission. I mean, that's a punishment now.
Very difficult to.
That's a punishment. Yeah. Your Lordship, I can't be punished because.
Not a punishment. See, the simple declaration which single judge must have made, that since there was no governing body, therefore all actions taken by the
Then the whole college possibly would have to be shut down, Your Lordships,
Yes.
in that scenario.
Yes.
But Your Lordships, I cannot be punished for something which was.
No punishment.
Your Lordships, now I'm demoted back, having worked so many years.
No,
Because
see, because of that, your order of suspension was set aside. Because of that, the charge memo must have been declared to be illegal.
may I,
And yes,
Your Lordships, of course, I was not the arguing counsel before the single bench. When I went through the rules, I found that the suspension actually has been issued by the correct authority. I mean, that's something I will have to tell the court.
then you want to be suspended.
I think probably that's something I'll have to accept. Charge memo they can come up with.
Very difficult.
But Your Lordships, and there's a direction also in the judgment that let the governing body be formed. And thereafter they can do. But Your Lordships, demoting me back to 24 years.
No, demoting, instead of demoting, it's mere declaration that consequences of the finding that
Yeah.
there was no governing body
Your
shall
Lordship,
follow.
I think that, Your Lordship, that's a little way beyond the exercise of judicial powers, Your Lordship, there. Because, Your Lordships, I understand that the relief can be molded, even not specifically asked for, but that was not the relief ever sought for there, Your Lordships. That is not the relief ever sought for.
No.
The only thing that the court possibly was asked to answer or decide there was whether it was with jurisdiction or not. And I'm
No, for that, the court was required to decide whether there was a duly constituted governing body or not,
But Your Lordships,
and whether the authority had the power or not.
Your Lordships, but the authority did have a power to, that particular authority who was issued it had the power to suspend. That's because the appointment letter said that.
Then you made a wrong submission.
No, I mean, that's why I said, Your
So you
Lordships.
cannot say that you are not there.
Then I'm not this is a different counsel who
You
appeared
should
there.
not say,
Yes.
should not repeat that submission.
But Your Lordships, but if I find that there is something there which is legally speaking would
You
be
can
incorrect. That's the
you
reason
can
I
say that, you can
submit
say,
that.
but you cannot say that since you are not there in the
Lordships.
earlier proceeding, therefore that mistake happened. No.
No, I'm not saying that.
Yes.
I mean, it's an assume that possibly I maybe have been arguing and missed the point. So, so suspension, definitely that person had the power. And there is a direction by the court also.
Who is
That you-
appearing for the other side?
Your Lordships, state would appear.
Yes. You tell us. Then single judge appears to be right. So this must be your stand also. And what kind of governing body? How are these institutions functioning without governing body? Close it. If you have the power to entertain disputes between two private persons, then at least you should look into these such colleges which do not have any governing body.
So there was a properly constituted governing body in accordance with the rule of law. That instruction I will have to take.
Take.
Well,
As requested on behalf of the estate, this is matter on after vacation. For him to seek instructions as to whether the governing body of which college? Which is
Aeronautics.
Three. Respondent number 3.
so was duly
Aeronautics
Education Society,
Society.
legally
Sunabeda.
duly constituted or yes.
Lordships.
Let us see.
Item number 10. See, where limited grievance arises, when a petitioner is a student of My petitioner is a student of Odisha Adarsh Vidyalaya, my lord, ex-student. My lord,
Yes,
my lord, she's paying for a direction to provide 15% reservation of seats in medical engineering college by citing the similar students who have passed 10th board exam under the Board of Secondary Education Odisha and
but she
12th
wants admission.
my lord, the reservation part, the 15% as per the
She
notification.
wants admission.
By appearing in the exam, she wants that reservation quota, that 15% reservation that is provided to the
Reservation, we understand,
My lord.
but finally we wants admission based on reservation.
my lord,
Want admission to which course?
to medical course, my lord,
To medical course.
medical course.
For which academic session?
My lord, the forthcoming academic session, my lord, that is 2024-25, my lord.
2024, 2025. All right. So what is your case?
My lord, may kindly see the notification that is at annexure to page 19. Here, my lord, I may be permitted to read.
Please.
The state government has directed for reservation of 15% of seats in medical and engineering college of the state for the student who have passed 10th board examination under the Board of Secondary Education Odisha from government high school and also have passed the 12th board examination under the Council of Higher Education Odisha from any government higher secondary school, junior college, and such reservation shall be horizontal covering all vertical reservation as well as unreserved group. My lord, here the present petitioner is a student of Odisha Adarsh Vidyalaya, my lord. That is she has got the certificate from CBSE. But my lord, the Odisha Vidyalaya, she's claiming parity as the Odisha Adarsh Vidyalaya is completely governed by the government of Odisha. My lord, may kindly see, she has also ventilated an exhaustive representation citing all her particulars. My lord, that is pending, my lord, with OP1, my lord. Here, my lord, she's only claiming parity with respect to the 15% reservation as per the 2021 notification that if the state, the students who have appeared under the Board of Secondary Education are getting that. So if the Odisha Adarsh Mahavidyalaya comes under the purview of because it is governed by the state, so there must not be any discrimination and 15% of reservation may be granted to her as well. This is the limited grievance.
No, but on what ground you are being denied? What is there?
My lord, the Odisha Adarsh Vidyalaya, my lord, is governed by government of Odisha, and hence the 15% reservation shall not be only applicable to the students who have passed 10th board and 12th round from the secondary education.
Annexure 2 is only a newsletter. Annexure 2 appears to be a newsletter.
My lord, it's a
not a
notification from.
No, it is
My lord,
not a notification.
My lord, it's a my lord.
It is a newsletter.
My lord, may kindly see for a moment. Here, my lord, the government of Odisha in information and public relation department. This appears to be a new. My lord, this is a notification that is being followed.
This must have a supporting notification, appropriate notification or resolution.
My lord.
It is not a resolution.
Well, for that aspect, my lord, I could not get the exact notification, but this is the instruction that is being provided. So, my lord, I have submitted an exhaustive representation stating everything with respect to my qualification and my parity with the. My lord, may kindly see annexure 3, that is page 20.
There is nothing that who has decided this, whether it is state government decision or not. We do not.
So your Adarsh Vidyalaya is affiliated to which board?
It's CBSE. My lord, the certificates we are getting is for CBSE.
Then this 15% is reserved for the decision.
My lord, I'm claiming parity with respect to that because, my lord, the students who are being passed from the Board of Secondary, Higher Secondary Education and Secondary Education, my lord, they are getting 15%. My lord, these schools are governed by state government, my lord, state of Odisha. So, my lord, I am claiming if Adarsh Vidyalaya is also governed by state, so 15% reservation may be
governed by the question of state. You are saying it is affiliated to CBSE or something.
CBSE, my lord. The certificates we are getting, my lord, from CBSE.
Then how are you saying that it is governed by state?
My lord, the Vidyalaya is being governed. The Vidyalaya is being managed and my lord, I have stated that, my lord.
Yes. What is the policy
In fact, this 15% reservation is in the light of Supreme Court's decision. So why?
Case 19. The information supplied to someone, but that policy has not been. And that policy is relating to the students studying in Odia medium schools, government Odia medium schools.
So it is also government Odia.
No, very. CBSE.
No, it's a government school. Government school, but its affiliation is to CBSE.
Yes, madam. Their examination pattern is CBSE. Their courses are CBSE course.
Courses are CBSE course, but all of them have to appear in the same JEE examination or that.
And medium is English, not Odia.
It is very difficult.
It's why I got 9%.
File your affidavit.
Then I take instruction.
Please seek instructions, because this 15%, the idea is that the residents of that state should be.
Not residents.
All the states of India are getting it.
Is because some of the states were giving preference to the residents of that state for the purpose of admission to medical courses. And see, a controversy had arisen that that should be open to the all the students, and in that background, throughout the country, because there cannot be this thing. If there is one seat available, then all the persons who qualify, they should be considered. In that background, the Supreme Court said that because those colleges are funded by the state governments, therefore 15% of seats can be filled. They can be allowed to fill up 15% of seats from the residents of that state. So and in that background, this 15% of reservation is there.
So far as medical admission is concerned, now 15% reserved for outside state.
For outside state. All right, the other way around.
And 85% for the concerned state. So in that 85%, this is the horizontal reservation within 85%, 15% of the student.
So, but this 15%, how can the state decide?
Yes, but that I have to see that notification, or the notification that in has not annexed that notification. But as it appears from the information supplied to him, 15% reservation has been made in respect of students who are prosecuting their study in Odia medium school.
How this 15% is out of 85% or
85%.
out of 85%?
Out of 85.
How can you do that?
Because my non-friend is submitting that CBSE.
So this has happened for the first time.
My lord, this particularly she had raised the issue previously, but she was debarred from it. And my lord, this information she received in a very later stage, my lord. So this is for the first instance.
File your affidavit, we will see.
This school is just like Kendriya Vidyalaya.
Adarsh
It is a
Vidyalaya, my lord.
society. You have enclosed Annexure 1.
Yes, my lord.
Society. It is registered under Society's Registration Act.
My lord. And my lord, it is being funded, managed by the government of Sri. So she is claiming parity with respect to other students.
No, this is.
Certificate is not granted by Board of Secondary. Board of Secondary Education is not granting you the
Central board.
certificate, but CBSE is granting you the
My
certificate.
lord, CBS is providing me the certificates.
That is the.
How this reservation can be? File your affidavit.
Yes,
sir.
Board of Secondary. Schools which are run under the Board of Secondary Education. So this is not under the
can they-
Board of Secondary.
How can they classify? From 85%.
Yes, from 85. That is the reservation within reservation. In fact, it cannot be said reservation with that 80%, 5% quota. Against that 85% quota, 15% is.
And then it is horizontal.
Yes, that is horizontal.
It is another problem.
Yes, ma'am. Why I am saying this is not reservation within reservation. Out of 85%, 50% is for open category. And rest 50% for reserve category. That 15%, from even 15% from open category and from 15% from reserve category.
Difficult. File affidavit.
File.
Issue notice. Then AGA accept notice on behalf of all of them,
My lord, all of them.
the opposite party.
P1.
I cannot appear for appointment to 3 men.
Opposite party number 3, who are 1 and 2?
1 and 2 government and information from public relations. I can appear for 1 and 2.
3, who is 3?
Chairman, Odisha Joint.
3 is Odisha.
Separate councillor.
My lord, Odisha Joint Entrance, Skill Development and Technical Education Department, my lord. Odisha J.
So again, you are
Government can.
So chairman is making party chair, Odisha Joint Entrance Examination. Their council is separate. They have a separate panel of councils. First, Mr. Rubil Palit, senior council is appearing for. That's the issue not.
a copy of. But he is senior advocate, he cannot receive, he should not receive notice.
No, his junior associate can.
Let a copy of the present writ application be served on Mr.
Rubil Palit, not a senior. So his Amitabh Miss, perhaps the associate is Amitabh Miss.
On the office of Mr. Palit, and senior counsel, who generally represents opposite party number 3. Also considering the urgency of the matter, which relates to admission to MBBS course.
My lord. NEET.
Neat and engineering.
Specifically for NEET, my lord. The courses, the reservation is for both the courses,
All
but
right, you are medical.
NEET.
Discuss matter on opening day. 18 June.
My.
Yeah.
Within first 10 cases.
No, my lord. I have not got the exact notification, my lord. This is the only information I have got. I have not challenged that notification. Because that notification only I'm claiming parity, so I need not to be challenged, my lord, that notification.
Then you don't have any case.
My lord, the main thing is the notification states 15% reservation for the students pursuing their studies in the Board of Secondary Education and Council of Higher Secondary Education. I am claiming that my school is funded, my school is managed by the government of Odisha. So my
So
certificate,
unless you question that notification which does not include your school or school of your kind, how can you?
my lord, the challenge comes in the second part, my lord. I have for clarification, I had made a representation, my lord,
Use
for clarification.
a representation. Use it's half-hearted approach.
Item number 11.
Mr. Rath, you should come forward with more details,
My lord.
and your drafting skills have to be improved.
Right.
You are young counsel. Arguing will not, only arguing will not suffice.
Right.
You have to be careful in drafting also.
My I'll
Yes.
Item 11.
May I please, my lord? Yesterday, Lordship has asked for a question whether the candidate should get a chance to appear after 3 chances. Being a backlog student in 8th semester. Lordship, I have verified the guidelines of the BPUT and I find one thing is similar, that is under Annexure 3 series, page 16. Lordship, may I place the relevant portion?
So you are placing something which is not on record.
No, it is on record.
Where is that?
Page number 16, your Lordship.
Of
Annexure
the
3 series.
writ petition.
Yes, your Lordship.
Yes.
The relevant portion is para 2. However, the said online examination for the intermediate semesters shall be treated as regular semester examination, and therefore the students who fail, remain absent, do not appear, do not register in some subjects or in all subjects will carry back papers in concerned subjects. Further, the students who have back papers in their intermediate semesters shall also be allowed to register and appear these online examination of intermediate semesters along with the regular students. Here, my lord, the pageant petitioner has already registered for the backlog papers, but somehow he could not appear in the said examination. Thereafter, his registration for further registration for the next year, his registration portal has been blocked. Only for that, he has given a representation to the OP number 3 to consider for the re-registration and to allow him to appear for the 8th semester examination.
That will not. Yes. You are
I'm appearing on behalf of Mr. Satpathy, Your Lordship. Lordship, we have sought for the instruction, but due to the election duty, law officer could not send us the instruction. Kindly list this matter
Law
tomorrow.
officer of what?
Lordship, we could not receive the instruction, Lordship. Kindly list this matter tomorrow, Lordship. We will
Tomorrow.
obtain instruction today.
As requested on behalf of the university.
University, Your Lordship.
BPUT. BPUT.
BPUT.
Item 12.
May it please your lordship. Petitioner challenges the inaction of the opposite parties, my lord, to evict the person who have encroached the my lord, petitioner challenges the inaction of the opposite parties to evict the person who have encroached the government land.
There is a decision of this court.
Yes, my lord, the
You can follow that.
Trinath Pradhan case, my lord. In case of medical college, sorry, the Lakshman.
Trinath, but here encroachment proceeding has already been initiated.
All right.
But since 21-22, it is.
So everything is there in that order.
WPC 3385 of 2024.
Yes, he is having. You have that.
Item 13.
Yes,
So, similar matter, my lord, fixed to
Similar.
10 yes, my lord.
similar.
My lord, fixed to 10/7. Similar matter, my lord, is fixed to 10/7/2024.
Similar
Yes.
matter.
Yes, my lord.
Let us see what is the matter about.
Virus of that repeal.
Virus of rules.
2013.
Hmm.
Group C, Group D regularization.
That matter is
Confidential appointment.
coming when?
Mr. Kuntia. This is, Mr. Kuntia, this is a repeal of. Yes, please,
My lord, I will provide that.
Mr. Kuntia, this is rule 4 of that repeal of Group C, Group D regularization. The rules 13. When is it posted? It's a batch matter, no?
That matter relates to that this is different. I am saying this is different. Those matters are relating to the school and master education. There we are saying that there is a rule. So at that point of time, instead of following that rule, they are appointed on contractual basis. This initially they are appointed on contractual basis. And by virtue of the policy December 17/9/2013, they were regular.
This is health and family.
Yes, ma'am. This is the health.
MPHW,
Yes, ma'am.
multi-purpose health worker.
This is not similar to that case.
But he is challenging the virus.
Because well, that IDC challenge in those cases, they are standing that initial 93 rules are there. Without following that 93 rules, they are appointed on contractual basis. So they are to be covered as 2013. This is a completely different case. And so something. May I notice in this case and I will find answer.
No, on what ground you are challenging? What is the ground?
Kindly adjourn the matter, my senior will admit this matter.
Got it. Will not issue notice. Notice coming. Issue notice. Accepts notice. Prayer.
Failure to violate the rules of total.
Come to paragraph 5.
Directing the opposite parties to count the period of service rendered by the petitioners prior to their regularization by way of granting national increments and service benefits.
So many petitioners are there. Their cause of action, their claims, their. All right, we will see later. Yes.
Item 14.
Published.
Right.
Item 14.
My lord, this is regarding amendment of the MBA. My lord knows very well in this regard because it relates to obvious case. That is the deletion of the provision regarding use of red light in the vehicle, in the post, in the cars. they are being used by the subordinate officials nowadays in the Odisha. My lord,
So what should we do?
no, my lord, I am, after that amendment, my lord, there is a complete restriction that there no red light should be used by the cars, by the officials. But still then I have given the photographs of Tahsildar, executive magistrate, NSC executives. My lord,
Photo is there.
yes, my lord, 25 and 26.
Yes. Tahsildar is sitting.
Tahsildar is keeping the vehicle and in the office. Another is the executive.
Can be, I always say this, that one day one can file a writ petition of the nature of public interest litigation, that this court should issue a direction that henceforth no one should commit theft.
No, that is not the case here, my lord.
This is what if the law is there and if that is being violated, then that can be seen in appropriate individual cases.
My lord, page 17, my lord, they have
We
been.
have seen such kind of petitions we don't entertain.
No, my lord, page 17, my lord, they have issued the notification deleting that provision, my lord. Page, Government of Odisha,
Yes.
page 17.
Yes.
They have issued the notification that the provision regarding allotment of the different designation is withdrawn. Annexure 2, page 17, my lord. Still then they are using. So I have made party to the commissioner, State Transport Authority to issue necessary direction to them not to use that red light also.
You are taking us to annexure 3.
My lord. Yes, my lord, I am speaking.
You are challenging this.
No, my lord. I am submitting that after that withdrawal of the notification, still then the officials are using the red light also.
So we cannot control that. This is what we are saying.
My lord, I have,
We cannot stop theft and such repetitions should not be entertained.
that is my submission. I have submitted a representation to the State Transport Authority and the Principal Secretary. They may consider that aspect also. That is the case, my lord. Page 27 is my annexure 5, my lord, representation.
I see direction to the opposite parties for issuing for necessary guidelines. The officer for the state not to use red light. Lights. Their vehicles in each of the of Central Motor Vehicle Group 1989 and the notification issued by the Government of India as well as the Commerce and Transport Department, Government of Odisha. So, when also for the petitioner has drawn our attention to certain photographs published in newspapers to contain that in breach of the set guidelines, the officials are still using beacon lights. So, in our considered view, based on such newspaper reports or photographs, this court is not required to issue any direction as sought for by the petitioner in the present PIL. So, it goes without saying that
we cannot record a finding based on the nature of photographs printed in the newspapers, magazine, newspapers slash magazines,
Newspapers.
from newspaper,
Newspapers.
newspaper, that the state guideline has been reached by the government official from the writ petition, a court's opinion is received and is accordingly. So, it goes without saying, however, that the concerned authorities are required to keep in mind the fact that the notifications of the Government of India dated 1/5/2017 and that of the state government dated 1/6/2017 are not breached.
Item 15.
On behalf of Mr. Patnaik, it is not see admission matter, let it come next week only.
Admission what happened?
My lord, he has not given me copy.
Admission is over.
Yes.
Then we have decided. Is the nursing course,
Nursing, please.
for the academic year 2023-24. Of the section compared case of the case
No.
on the date and
On giving NOC, my lord.
seeking for NOC, not for NOC for which year?
23-24. 23-24. It is in
So, see. Comma and the signature. For the 2020.
Lord, as on today, they don't have given any copy to me for this year. I have got only one copy for 24-25. So most of the cases are over.
Most of the cases are.
Yes.
Item number 16.
That this is arrangement out of the personal case of the petitioner. Arrangement out of the way we provide proceeding. Some payment demand was made by the court for regarding stamp duty and he is agreed by that. So he has filed this, so it cannot be in the nature of PIL that is actually human. Once you may hear the values.
Not here.
There is no representative on behalf of the petitioner. Discuss matter tomorrow.
Item 17.
May please, my lord. Here, my lord, the petitioners are residents of village Dubogana and they're challenging the inaction of the opposite parties on taking action on illegal encroachment, my lord, blocking by opposite party number 5, my lord. And by that illegal encroachment, my lord, the passage of the passage, which,
Encroachment over a public land.
it is recorded in favor of the government, my lord.
So you can take aid of Trinath Panda. Trinath Panda, there's a procedure laid down in that decision. You can follow that. Trinath Panda.
Item 18.
Lord, 18 is a nursing matter. The petitioner counsel is not there. The copy has been given to me. It is for
Again, same thing, NOC.
NOC for 24-25. He has applied for. We had given a letter regarding some deficiencies to be complied with. His allegation is that he has already complied with. So necessary steps will be taken for consideration for NOC for 24-25. Time is there.
So are you following that GKF?
Yes, my lord. Yes.
Are you adhering to the time?
Yes, my
schedule?
lord. This year we are going to adhere to the timetable as scheduled. Or let it come next week. I will give instruction for this. 24-25.
No, but this is not nursing. The diploma in medical lab and tech.
Yes, ma'am. Same timetable is same for all the courses.
I don't mind.
Great.
Material grant of benefit return 23-54.
23, not 23, 24. It is 24, 25.
24-25.
Sorry, 24-20. Prayer for afterwards.
After?
Vacation.
To vacation.
Ma'am.
As requested on behalf of the petitioner, this matter on after vacation. Yes.
Item 19.
Is a public interest litigation. I am filing the photographs of the with GI tag. I have with that app. I have taken the photographs with GI tag with longitude, attitude, where there not by illegal mining is done by the sand mafias. All the photographs kindly.
We will not see that like this. Let us see.
Similar disposed of yesterday that I am finding that number. That in view of the revised sand policy and the judgment of the information person, but your lordship has observed that the comment will take us. Yes. That yesterday your lordship.
With that my lord, your lordship may dispose.
I'm just
Give the number.
Number with your lordship.
Yes.
I think 15 item.
All right. Yes.
Yes, if that direction was already done, that may be my lord passed in my case.
That was in respect of category and the Banki.
Yes, this is with regard to Pata. This is with regard to Patamunde. I've given all the photographs with longitude and altitude, my lord, so that the exact position where they are digging, that is known, my lord. With all machineries there and with Haiva, they are lifting the sands, my lord.
16.
No. He has. We have that order.
Mark, like,
Yes. Item number 20.
May I please, your lordship? Hello. This is a case. Petition
No,
of.
that is not required to be taken, Mr. Counsel. That is not required. We will pass order.
Mark. Because this.
We have understood.
They have come forward with the new sand policy, and we have added some guidelines in earlier judgment. So, in terms of that, this will.
My lord.
I may be pardoned, madam.
20.
Opinion of the three, madam. That is the ministry, but my learned senior has not served the copy on us.
My lord.
Yes,
Let-
what is this about?
Challenging the rule, elementary cadre rule, 2019. The ultra virus.
Yes. What is virus?
Provision 15D1 of the amendment rule
What is
2019.
virus?
Some
it connected?
some non-qualified teachers have been promoted to the next cadre, which has been banned by the NCT and the RT Act. My lord, similar case already counter and regent rapporteur have been filed. And one
We
new
are
case,
putting this question, what is virus?
virus, my lord, this is violating the rule NCT norm and RT Act 2019. 2019.
My lord is hinting at your cause title
My lord,
in the matter of an application challenging.
Methods of recruitment and condition of service of teachers, officers, amendment rule 2019
As illegal.
as illegal, arbitrary and ultra virus in respect to the rule.
Ultra virus means something beyond the viral fever you have.
Pardon, my lord.
All right, no problem.
Sorry, my lord.
Yes, it happens. So-
Provided the teachers appointed against the advertisement
So-
published
So
prior.
what do you want? All right. What do you want?
I am challenging the provision 15D1 wherein
Yes.
the teachers, those are appointed prior to February 2011 have been exempted from passing of the OTAT, which is a TET in RT Act. The teachers on the commencement of the rule have to qualify such minimum qualification which has been provided by the NCT. Accordingly, now the state government arbitrarily promoting the non-qualified OTAT teachers from the next level.
Who are you?
My lord, I am a teacher.
This is a public interest litigation.
No, my lord, I am a teacher. And I am having OTAT certificate, I am qualified, but I have been deprived from promotion.
From promotion.
Promotion, my lord.
Why?
Because non-OTAT teachers are promoted, but those are qualified as per the term and condition of the NCT and RT Act have been deprived of.
Why?
They're exempted from the OTAT as per the rule 15D1 of the amendment rule 2019. This is the dispute, my lord, OTAT holder and non-OTAT holder. When the RT Act came in 2019, as per the provision under section 23(2), it is mandatory for all teachers have to be qualified OTAT, TAT. Now, in Odisha, the state government arbitrarily exempted them to pass the OTAT. Therefore, though they are senior, they are without having OTAT qualification have been promoted. In similar case, my lord, already state government filed, and we have already submitted the regent affidavit. And if that will come with this tomorrow.
Tomorrow?
My lord.
That matter is coming tomorrow?
That one item already, my lord, listed tomorrow. That is WPC 10430.
In that case, counter affidavit
No,
has
no.
been filed.
No, my lord, counter has been filed in it, WPC 17780, WPC 21547.
When are they coming?
Last occasion, your lordship be directed to list this case with that, but it has not been.
Coming tomorrow. Tomorrow.
Tomorrow, my lord. I'm submitting the list, sir. All these cases.
Tomorrow you'll hear.
Let them serve a copy of the same. We don't have a copy.
Item 21.
Right, my lord.
Please, your lordship. Here now the limited prayer of the petitioner before lordship is the petitioner grievance under annexure 6 and 8 Miller. These are pending before the authority, that is OP number 3, it is the concerned authority Miller. If your lordship will permit me so that what are these grievances, I can explain it to your lordship Miller. And the petitioner before your lordship Miller, he had approached the Honorable Court and under annexure 2, that is in order dated 16/10/2023 Miller. 16/10, that date is also very that is important Miller. This Honorable Court under annexure 2 Miller at page 18 Miller starting. Your lordship may kindly have appreciate. I am just reading out the ordering portion of that order, page 20 Miller. Directed the authorities Miller. Have your lordship got annexure 2 Miller, page 20 Miller. Miller, direct the authorities OP number 213 Miller to consider the grievance of the petitioner as the grievance of the petitioner before.
Please come to your prayer portion.
Miller.
Prayer portion.
Miller.
Prayer
portion Miller, that has been become infructuous Miller. Thereafter, what happened, your lordship may kindly turn to the next annexure Miller. That is my grievance only to that extent Miller. It was communicated under page 27 Miller on the very second 2 days after passing of this order.
See,
Then your lordship may kindly
come
come to.
please come to prayer portion.
Yes, Miller.
So the first part has become infructuous.
Yes, Miller. The other part is there, Miller.
Come to the second part.
Miller. This further, this Honorable Court may kindly please to direct the institute to allow the petitioner to make application for renewal such and such in the physiotherapy for the academic year such and such.
So
That
who has
this
stopped
part
you?
is there, Miller.
Who has stopped you from doing?
Miller, my grievance is there, Miller. Unless they will consider my grievance, I cannot make application, Miller, because it is a case of renewal. I am an existing institution since 2018, Miller. Your lordship may kindly appreciate annexure 1 Miller. That is my last year recognition. That is last year's NOC Miller.
Last year NOC was granted.
Yes, Miller. Last year NOC. Last year means 2023-24. I am our controversy is in respect of 24, 23 and 24. 2022-23 was granted under annexure 1 Miller. My institution.
2022-23 was granted.
Miller.
Then did you apply for 2023-2024?
Yes, Miller.
Then what happened?
In respect of that application, Miller, since they remain callous for a period in spite of an application, in spite of all compliances, Miller, I was constrained to approach this Honorable Court, and this Honorable Court, considering my grievance under annexure 2 Miller, on 16/10 Miller 2023 had been pleased to direct them to complete the exercise in 15 days Miller. That is the specific direction. Miller, after 4.5 months later, Miller, under annexure 5, your lordship may kindly glance, kindly appreciate. Under annexure 5, that is 1 page order, Miller, on 27/2/24 Miller, page 28 Miller, they directed the concerned director of the institute to appear in person on 29 February Miller. On their 29 February Miller, we made an application and that has been endorsed Miller under annexure 6. Your lordship may appreciate that is my grievance only Miller. Miller says the institute director was hospitalized by that moment. He sought for 5 days Miller. That is still pending Miller. They had called upon to come with all of the application, all of the relevant documents for verification Miller. I sought for 5 days time since I was hospitalized. I was means my client's chairman Miller.
So that's this 2023-2024 goes because of your hospitalization?
Yes, Miller. My grievance is there, Miller.
Now your 2024-2025 this case can be considered only in accordance with law.
Yes, Miller.
So now the date of application is.
My grievance may be considered in accordance with law. Your lordship has been pleased to pass, have been pleased to pass in other cases, that sort type of
In
order.
accordance, yes, in accordance with law, they will reject.
My lord, my,
In accordance with law, they are bound to reject.
yes. My lord, my grievance are there.
Grievance may be there. They will act in accordance with law.
Millard, series of institutions are facing similar problems, Millard.
Maybe facing.
That must have come to your lordship judicial notice, Millard. Series of, not only the single
Yes, you are
petition.
right. And in future, they will not do that. They can't do that. They will have to stick.
Millard, for their inaction, we are being exploited. We are existing institution, Millard. Our application was pending, Millard. They called upon our institute chairman to appear on 29, Millard. We sought for a 5 days time, Millard. Still that is pending.
Sir, if we go by your prayer.
My first person, my first poll is in progress.
No. You had admitted students.
Yes. Millard, that is admitted in respect
That is an offense.
Millard, that is Millard, my student. We have admitted the student because for the continuance of our
How can you continue? How can you allow illegal admissions?
Millard, that prayer is completely within the discretion. I have made the application I've made our grievances, Millard, under Annexure 6 and 7.
All right, enough.
It may be disposed of according to law, Millard. Your lordship may kindly observe to that extent.
We cannot dispose of contrary to law.
Oblige, Millard. Your lordship may kindly, with good observation, I am praying to dispose of my application.
Petitioner has filed the present writ application with following prayer. First off, it
Millard,
claims
should I pray for withdrawing of my writ
and
application?
counsel for
With a
the
limit.
petitioner, after some argument, seeks permission to withdraw this writ application with a prayer, with a liberty to seek his remedy before
My lord.
appropriate authority. This application stands disposed of. Dismiss as withdrawn with the
Your lordship
liberty
may
and
say disposed of, not
all and
dismissed.
disposed of. Item 22.
Oblige.
Ma'am, please, madam. The petitioner, their public spirited persons espousing the common cause.
That we
Okay.
have experienced.
My lord,
That we have experienced that most of the petitioners of the PIL are publicly spirited.
my lord.
Yes. Let us see how much public spirited you are.
That is in Bulla, my lord,
Yes.
in Sambalpur district, with regard to unauthorized construction of Pakka building over the government plots and illegal cutting of big trees and for their personal use, my lord, thereby polluting the entire atmosphere of that area, my lord. Your lordship kindly turn to Annexure 1, wherein the plots, I have indicated, my lord, 5531, that is Patita, government plot, and 3531, that is also Patit. Thereafter 3775, that is also Patit. And your lordship can find that is very close to the power channel, and that is.
Where is this place located?
My lord, that is on the very close to the power channel, my lord, in Bulla town, my lord. In Bulla town, Sambalpur district,
Anything.
my lord.
Where is it? In Cuttack?
No, my lord, Bulla town, Sambalpur district, my lord.
Bulla town.
That is very close to power channel, my lord. That is the lordship can see. And that is also close to the Surendra Sai Medical College, my lord. Your lordship can turn to that area was developed, and in some cases, your lordship can turn to Annexure 7. It is the complaint given to the Inspector of Charge, Odisha, from Odisha Hydropower Corporation, my lord, under Annexure 7, your lordship can see that by it, your lordship can turn to Annexure 7 at page 29.
What is this? This unauthorized construction Pakka building over plot number 53530.
My lord.
Kisam Patita means?
That is belonging to government.
Huh? Hello land. And this, yes, let an affidavit be filed, we'll see. Let an exhaustive counter affidavit be filed on behalf of the state opposite parties within 6 weeks. This matter on 8 weeks. Item 23.
Item 23, my lord, I am on behalf of Mr. Kaniskarato. He has requested on the ground of his personal difficulty to seek an adjournment before your lordship.
When do you want?
My lord, next week, my lord, Monday.
What kind of tuition is this? Government has requested on behalf of the petitioner this matter on after vacation. Item 24.
Episodes. It's a very limited grievance in the repetition lordship. The opposite party lordship now constituting the village RD road.
We should fix PIL, one day should be fixed for public interest litigation. Not every day. Yes.
Now,
What
my
is your
prayer in the repetition that your lordship, the opposite party is now constructing the village RD road.
Huh?
The opposite party is now constructing the village RD road lordship.
Okay.
And that RD road is passing through the Gram Panchayat
What we-
lordship.
Yeah.
And
What
during
village-
course of
village-
such construction,
Village?
RD road also, RD road.
RD road.
Yes, my lord.
RD
During-
is Latin for me.
Revenue.
Rural development.
Rural development.
Yes, ma'am. They are constructing during course of construction the such RD roads, they are making it too height. Such height is affecting the landed property and so for the residential persons. So my humbly request is that height should be within the earth level, that should be too high. I filed representation before the respective opposite parties, that is since January lordship. Till today that has never been carried out. Rather they are constructing roads. This is my limited prayer. That they construct, I have no objection, but their certain height, their height has to be maintained to within the earth level.
Prayer is at praise 8, my lord.
Hmm?
The prayer is at praise 8. You
Page
must
8,
be
yes.
kindly page use the
But
prayer.
grievance appears to be genuine. Because normally the tendency is to say lay roads. After every laying of the road, the height is increased. And
That must have been
adversely-
considered, my lord. That must have been considered by the implementing authorities, my lord,
Let us
executing
see.
authority.
Not at all, your lordship. Not
Because
at
they
all.
cannot,
Let us speak. All right, file
that
your
must have been
affidavit.
done, my lord.
Huh?
That must have been done with you.
File your affidavit. That has been done, then we'll 6 weeks, 8 weeks. Item 25.
Oblige, your lords. My pleasure, lords. The limited grievance of the petition is that his balance amount of the cost of the material has not been handed over to him.
I
Although
have,
the materials were
my
received.
Lord and friend has given me a copy of the writ petition yesterday, my lord. I'm filing a vakalatnama. Lords may grant me 2 weeks' time to file a reply.
Annexure 4
It's,
is
a- it's in the,
undisputed.
it's, my lord, writ petition for recovery of money.
There is no recovery of money. What is admitted, you must pay.
Lords may kindly see what is his prayer, my lord.
We have seen the prayer.
Well,
You may file your affidavit
I'll
stating
file
that that is not admitted. We will dismiss the writ petition. But if we find that that was admitted and that has not been paid, then the situation
I'll, my
may be
lord,
very
my
difficult.
lord, yesterday only my Lord and friend has given me a copy.
All right,
Lords
you
may
file your
grant me,
affidavit.
my lord.
8 weeks time is allowed for
I'm filing the vakalatnama, my lord.
the file your vakalat on whose behalf?
Opposite part number 1, my lord.
Mr. So enters appearance on behalf of opposite party number 1 by filing a vakalatnama which has been taken on record. 8 weeks time is allowed for opposite party number 1 to file a counter affidavit. Stop. We further observe that in the meanwhile, if any outstanding amount is found to be admittedly due to the petitioner, the same must be paid to him.
For opposite part number 2 and 3.
Hmm.
Government, my lord, 2, the horticulture department will,
No,
is there.
1 and 3.
No, you are, who is one?
One and
I'm
three is
only
corporation.
appealing for the 1,
1 and 3 is corporation.
Which corporation?
the Agro Industries Corporation.
Agree. So you are representing 1 and 3.
Yes.
1 and 3.
1 and 3.
2 would be by government, my lord. Director of
2 has no role to play.
2 has no
Assistant
role to
Director of Horticulture.
Item 26.
Obliged.
Legal lordships. Whereas in this case, there has been subsequent developments. And I seek your lordship's kind approval for withdrawing of the writ petition and giving liberty to file a fresh writ petition. Because in the month of April, my lords, I have given another representation. So that has to be incorporated as an annexure in this writ petition. So may I pray, my lords, lordship may allow me to withdraw the writ petition to file it fresh writ petition. Liberty.
No, but why don't you file an additional affidavit?
Additional
Instead of withdrawing
affidavit, yes. I have already prepared it, my lords.
Do that.
Yes, that I have prepared it.
Instead of withdrawing the writ petition, you can
My
file
lords,
an additional
lordship may
affidavit.
call this matter day after tomorrow, I'll file the affidavit. All right. Day after tomorrow.
Learned senior counsel appearing on behalf of the petitioner states that in view of certain developments subsequent to filing of the present writ application, certain documents are to be brought on record by way of additional affidavit.
Obliged, my lords.
So as requested, this matter on Monday.
Monday, my lords. Much obliged.
The learned counsel for the petitioner shall be at liberty to file an additional affidavit in the meanwhile.
Much obliged, my lords.
Saying that you withdraw and file, this is the
Friends,
practice.
yes.
So it
Liberty, yes.
it is fresh
I'm
matter.
conscious. I'm conscious of that.
That is why I was suggesting, subject
Yes.
to,
No, your lordship's word will prevail over me.
counsel and senior counsel appearing on behalf of the petitioner seeks permission to withdraw this writ application with a liberty to file a fresh writ application in view of subsequent developments of this application.
Because a representation recently has been given to pay the
Okay, to
interim
the-
compensation
Draw.
from the date of the judgment of the Supreme Court till date, because we have not been, the farmers have not been
This
paid.
was all.
So that is why, in
With
spite of the
liberty, yes.
judgment of the Supreme,
Yes.
obligement.
27.
May I please, my lord? My lords, like parents, the teachers also have a great role in shaping the lives of young students, my lord. But in the present case, my lord, the petitioner is a student of final year law with opposite party number 2. My lord, a small squabble was blown out of proportion, as a consequence of which, my lord, under Annexure 10 at page 34, certain punishments have been imposed. My lord, my challenge to the impugned annexure, my lord, is first, my lord, the allegation on the basis on the allegation of a complainant, my lord, who was sharing the hostel room along with the petitioner and 2 other students. As per the allegation, my lord,
Let us come to the impugned order
yes, my
first.
lord, your lordship may kindly see annexure 10 at page 34. Slipshod inquiry, one-sided inquiry, and thereafter these punishments have been imposed. Your lordship would see
Which institute?
Siksha on a Southern University, my lord. It's a deemed university, my lord. Annexure 10 at page 34, my lord. May I place it, my lord?
Yes.
This is further to our communications earlier regarding the act of indiscipline by the following students inside girls' hostel. As per the complaint of Mohita Adak, a student of BA LLB, Sushri Subhashri Mahapatra, the present petitioner, my lord, Akriti Srivastav, Barsarani Mahapatra. Based on the facts and findings, the delinquent students are found guilty of gross misconduct and indiscipline. Accordingly, the final decision taken by the competent authority and the following punishments are awarded to them as below. The errant students Sushri Subhashri Mahapatra, Akriti Srivastav, and Barsarani Mahapatra to be suspended for all academic activities of the institute for the current semester. Each of 3 of them are imposed with a monetary fine of 15,000, which has to be paid within 10 days from the date of the order. All 3 of them have to submit an affidavit in non-judicial stamp paper undertaking not to repeat such activity in future. Apart from this, Subhashri Mahapatra, Akriti Srivastav, and Barsarani Mahapatra to be removed from the hostel permanently within 7 days from the date of the order. Lord, your lordship would kindly see Annexure 1 at page 70.
So the current semester comes to an end when?
My lord, the final exam is supposed to be held on 22nd May, my lord.
They cannot appear.
My lord,
They cannot appear.
they cannot appear, my lord. And your lordship may kindly see the complaint. The complainant says that she was assaulted by 3 of us. Your lordship may kindly see my reply on Annexure 2 at page 16. We make serious allegations against her. We say that she was taking semi-nude photograph of the roommates and she was sending it to her boyfriends. But my allegation goes under the carpet. No inquiry is held to my allegations. But one-sided inquiry is held just to appease the parents of the complainant, my lord. And now they have imposed a punishment asking me to give an undertaking not to repeat such kind of activities. When I am innocent, my lord, I have to give an undertaking that not to repeat, and there's an FIR against us also. But we lodged an FIR, but there's no complaint, and I filed a CRLMP also. And your lordship may kindly see Annexure 2 at 16, we give a reply. 20th of March, there was supposed to be an inquiry. 20th and 21st inquiry is held. But thereafter, Annexure 4 at page 18 is my reply. But
What is this National Institute of Law?
they have also a faculty of law, my lord.
Private?
No, it's a deemed university, my lord. Private.
Deemed university,
Yes, lord. Private. Yes, my lord. Private university.
Can we entertain?
My lord.
Should we entertain?
My lord, with great respect, my lord, Honorable Apex Court, my lord, has held that one has to see whether a party performs and discharges public functions. Once it is found that it discharges public functions, then thereafter writ under Article 226 can lie, my lord. I don't have a copy, my lord, but not sure. Young students, my lord, they could have easily resolved the issue.
Which place this university is located?
Bhubaneswar, my lord. I would only request if your lordship would be kind enough to issue notice by special messenger. My lord, I can take notice on them and matter can be posted next week, my lord. And the prayer, my lord, it's within the reach of the university. It's not that they cannot do it, my lord. They can hold that extra exam for me also.
No, when is the examination?
My lord, it's scheduled to be held on 22nd, but as per the last annexure, it is scheduled to be held on 22nd of May, my lord. They can hold a special exam for me also, my lord.
Oh, they can hold the result examination for you on.
Your lordship may kindly visualize the stigma which I'm going to carry over my head, my lord.
Issue notice. How will you serve notice?
My lord,
How will you serve notice on him?
my lord, by special messenger. Otherwise, if your lordship would direct, I can send it by email also. We can. Now, High Court rules also permit we can serve notice through email also, my lord.
Upon so and so through email. Let us try. Email, let us try. See what can be done tomorrow. List this matter tomorrow. Do it by today,
Yes, my lord.
tomorrow. Mail ID.
Mail ID.
I'll find out. My mail ID would be there. Mail ID is there also. My lord, I'll serve by email.
Shiksha Anusandhan. I think Mr. He was doing tax matters. I do not know. Mr. Siddharth Rai used to appear for Shiksha Anusandhan.
Besides serving through email, I'll also serve a copy on him. I'll ask him if he can appear.
No. Just now, senior advocate.
Lordship may permit me, I will take notice.
My learned friend is saying that he'll take.
See,
Okay.
they are children. And they may have committed this misconduct. But you have to be compassionate. See, we ignore some of the gravest of misconducts. And at this age, that might have happened, that might not have happened, we don't know. Please talk to the Vice Chancellor.
Right.
If they can be given a chance, let them given a chance. All right. If they cannot be given, then surely we shall adjudicate if we are required to do. They
So
can
Lordship may keep it on Monday.
on Monday, on Monday,
Or Friday, my lord.
on Friday, and you can intervene. You are representing them. You are a responsible lawyer. You can talk to the those girls. The vice chancellor may also. We shall also issue some note of caution to them in our judicial order. But just think of.
Lord, it can be resolved.
Please try to resolve.
I'll serve an extra copy on my friend, my lord.
Please do it.
Extremely grateful, my lord.
Issue noted. Mr. Bairal and council accepts notice on behalf of the university, Swayamsipura University, to discuss this matter on Friday as the first case.
Item 28.
Let one pass over.
Why, sir? Pass over. 28. Just a minute. Yes, sir.
Here, compliance affidavit, everything, my friend had taken time to obtain instructions regard to this compliance. That is why.
My lord, senior counsel R.P. Kaur will be appearing. He'll be having some clarification to make. One
Last
short-
day also there is
My
for
lord,
the same
he-
reason the matter was adjourned.
My lord, he's in old court number 2 on his legs. One pass over.
Ask him to come. All right.
Yes.
So take a file. We will take up.
Item 29.
Yes,
Like
complied with.
the order has been complied with and direction has been issued by the authorities to record the name, record the land in the name of the present petitioner. I can give a copy of the order because I don't have Xerox copy. I'll get it Xerox and give it.
It shall be, you should be obliged to him.
I will give a copy. Okay.
All right. Complied with.
Item 30.
Lordship may grant some time to comply, Lord.
What was the order?
Order passed in a writ appeal and the contempt application has been filed against the interim order. My lord, page 22. Lordship may grant some time.
All right. How much time?
Lord, Lordship may keep it on reopening. By that time, Lord, we have paid. They have not paid.
All right, let us see.
Salary, they have not paid me. That's
This matter on 24th June. This was to enable and counsel for the contender to seek instructions and inform this court about full compliance of this court's order, violation of which has been alleged in the present contempt application.
obliged.
Both cases. Yes.
Item 31.
In 31, my lord, on behalf of Revisional Municipal Corporation, I have instruction that the order has been complied with and I will file an affidavit. If some
Your-
time is allowed.
Your statement is enough. Learned counsel appearing on behalf of the
My lord.
Ranjan Pandal and counsel appearing on behalf of the
And may I say after
Contemptor.
vacation?
contender states that this court's order, violation of which has been alleged in the present contempt application, has been complied with. Stop. There is no representation on behalf of the petitioner.
And it may also be recorded in Niranjan Panda 1.
There is no representation on behalf of the petitioner. Stop. It seems that because this court's order has been complied with, the petitioner has lost interest. The contempt proceeding stands dropped.
Item number 32.
So order has been complied with, we have communicated the order to petitioner.
Complied with.
Item 33.
Non-compliance of order at Annexure 1, 19/123. Yes.
Yes, order has already been passed on 15/3/2024. I can not
Yes, it has.
give a copy.
My lord, may keep it to reopening. I will get it by you. Just see if it is complied with, then we can give you liberty if you are
No,
agreed.
even the Narottam Ratha has been, yesterday we have seen.
And yes,
Narottam Ratha,
Yes,
you have challenged it
yes,
before the
but we
Supreme
have
Court.
taken a decision already, Lord.
You have complied with.
He has
Implemented.
already passed an order.
complied with. Complied with, Mr. Both the cases.
Item 34.
Well, 34, for non-compliance of the order under Annex 1, I am before your lordship. I have filed a contempt petition that was disposed of, directing the opposite party to comply the order. That has not been done as yet. So I am before your lordship once again. The lordship may kindly turn to page 10, last portion, your page 11. Page 11, and submit that if an employee is ordered to work in a higher post, though temporarily, he is entitled to the salary attached to the higher post. We have considered that aspect of the matter, and in view of the decision referred to above, it is directed that the petitioner shall be paid the differential salary of the promotional post for the period he had worked. So only differential salary has to be paid. That has not been done.
Yes.
No, sir. First time it has come, Lord, so I will after see that it's paid, Lord, so Lord may call it immediately after the holidays, Lord.
All right. As requested on behalf of the continuous, this matter on first week of June. So as to enable him to seek instructions. So as to seek instructions as regards full compliance of this court's order, violation of which has been alleged in the present contempt application. Yes.
Item 35.
Obliged.
May I please? Non-compliance of my lord's order dated 31st July 2023, my lord, Annexure 1, Annexure 1. While allowing the writ petition, this court granted 4 months time to comply my lord's order from the date of receipt of copy of this order, my lord. Your lordship's order communicated to the alleged contemnors along with application dated 16/8/2023 by registered post, my lord. Though in the meantime, near about 68 months have already passed, but till today no communication has been received by the petitioner, my lord. And the petitioner before my lord is a senior citizen aged about 74 years, my lord.
Yes.
My lord, I have an instruction to appear on behalf of the opposite party's contemptuous manner. I have an instruction to appear on behalf of opposite party. We will file our so-called compliance.
No, but why are you complying with the order after the contempt applications are filed?
My instruction is that they have complied, but I don't have the.
Is Mr. Swanko accept notice on behalf of the contender?
My lord, I am appearing along with the learned DSJ.
Learned?
DSJ, Mr. P.K. Pal.
DSGI, PK Pari.
Deputy Solicitor General accepts notice on behalf of the contenders. So this matter on second week of June, second week 24. So as to seek instructions and inform this court as to whether this court's order, violation of which has been released in the present contempt application, has been complied with or not.
Item number 36.
Obliged.
Let's say in item number 36, it is a second time contempt. And after first contempt was disposed by this honorable court.
So I am gone to the order.
Government
It has to be.
Yes.
Has to be complied with. Also, after holidays, Lord, I see that it's complied with, Lord. Some benefit, service benefit has to be given to him, Lord.
No, it is not complied, my lord. Because
He is not saying that it has been
not complied. I will comply it after the holidays.
yes,
Right? Top. Also, so it's tunable. Yes,
Item 37.
Similar matter, my.
similar.
Yes, ma'am. Same authority, same.
Item 38.
Public matter.
My lord, let it come, my lord, after vacation. my lord.
Whether it has been complied with. Mr. Samantre.
Plus, because it has been come out for the first time superintendent of police, I will obtain instruction, so.
Time out. Yes,
39.
yes.
Also, here also, also, first time it has come, also.
Time out.
Item number 40.
May please your lordship. My lord. Contemptor did not comply with the honorable court's order, my lord. Honorable court was pleased to pass order on dated 20th March 2023. Then petitioner submitted a representation along with the honorable court's order before the contemptor.
So where is the order?
Page
My
9,
lord, your lordship kindly see page 9.
There is no order.
That honorable court directed to submit grievances. Land has been acquired by the
There is no order, Mr. Counsel. There is no direction.
my lord. Basing upon this order, petitioner submitted. Your lordship kindly see page 11. That is application of the petitioner.
Whether his this representation has been considered, Mr.
Representation
not
then
so.
also
That instruction, I don't think.
Seek instructions because though there is no direction.
No,
but
yes, again,
if
I will obtain.
there is a judicial order, let it be respected. Order.
Item 41.
May I please your lordship? Lord, here is a challenging the violation of order dated my lord 24th August 2023. It start from page 14 to 19, your lordships. Page 18, lordship, paragraph 9.
Item 40.
41.
Yes, which page?
Your lordship, the page 18, your lordship, 180, your lordships.
Yes.
The last paragraph 9, your lordships. In the above view of the matter, this court is of the considered opinion that since the demand raised by the authority is in respect of package number OR 2646, to which the petitioner is no way concerned, and as such, this fact has also been intimated to the petitioner by letter number 3180 dated 26 July 2019, which was not received by the petitioner as stated by the learned counsel for the petitioner. My lord, thereafter, my lord, I am then 4 lines, your lords. It is incumbent upon the opposite parties to rectify their own mistake and revise order of impugnation dated 22nd January 2019 by relieving the petitioner, my lord. The word is, my lord, relieving the petitioner from imposition of penalty so far as package number OR 261456 is concerned, my lord. Thereby, this court remit the matter back to the authority concerned to act in consonance with the Solomon affirmed counter affidavit filed before this court and pass appropriate order in accordance with law.
Yes.
But they,
My lordship, my friend, if
They-
he has completed, lordship, may kindly come to page 28, annex 7. Revised order was passed and he has challenged the same order before this honorable court, and next page, page number 30, annex 8. He challenged that and subsequently the writ petition has been disposed of. Thereafter this continues.
yes, sir, the court said because there is a order of relieving, my lord.
my lord, those since there is a order of relieving, so court, my lord, the end not did not entertain, your lordship granted liberty to appropriate forum, your lordship.
What is annexure 8?
Annexure 8, he
Annex-
challenged that annexure
No.
7,
Let.
which because he says that has been passed by the authorities in violation of the original order passed in the writ petition, Lord.
That is not a contempt.
No, no, my lord, yeah, my lord, the court said that you relieve from the penalty from this package and relieve from the penalty from this package, my lord. The what is the then, my lord, they, your lordship, prior to that, they annexure 6, my lord, they withdrawn, my lord. Your lordship pays 27, my lordship. Kindly have pays 27, my lordship.
No, but you challenge that, see, there some decision was taken in the light of an order.
Yes, lordship.
That decision, according to you, was incorrect.
In violation of court order.
Incorrect in violation of the
Exactly, as your lordship.
This is what the Supreme Court says, that if some decision has been taken, it cannot be said that there is a deliberate violation.
No.
Therefore, contempt,
Only one humble submission, your lordship.
and then you yourself challenge.
Yes, my lord. The court did not enter because it's a violation of your lordship. Last paragraph 4, your lordship.
Yes, 4. Lord, can I look at paragraph 4?
Submit. My lord, I request, my lord, after advancing some argument, learning counsel of the petitioner that the petitioner may be permitted to withdraw, my lord, with the liberty to pursue his remedy before the appropriate forum, my lord. We are submitted, this is a completely violation to the order of Honorable High Court, and court did not entertain, my lord. So we taken liberty. After that, we came to court. This is the violation of court, my lord. This is, your lordship, the order operating party, your lordship. I mean, the word is, it is on their basis of counter, on the incumbent on the part of authority to relieve the petitioner towards penalty for this package, my lord. But this word is the only, if this order is still, my lord, this Honorable High Court order has still neither modified nor it is set aside by High Court, my lord, Honorable Apex Court, my lord. Basing on once the court said that you relieve from the penalty from this package, but this is a direction they can't impose, my lord. Sorry.
Sometimes it happens that, and many a times,
Yes, your
in
lord.
my orders, I find there are so many mistakes. But here also, when you have repeated this word relieve.
Lords, your lords.
The relieve has been typed RELIVING. It is not RELEVING. So if
Relieving that just small.
that is strictly construed, then no contempt is made out.
No, relieving, my lord, from the discharge of the burden from the petitioner, my lord. That word relieving, your lords. That word, your lordship, saying 2 words, relieve. Lord, his relieving word is word RELIVING, my lord. 2 words, my lord. And the relieving from the for imposition. The word is for imposition of penalty. Thereafter, your lordship, relieving the petitioner from imposition of penalty so far package number, which is 145, your lordship.
There is the order.
Page 19, your lordship. After court order, your lordship.
We have recently decided a case, Mr. Counsel. Very recently.
I have go to the, my lord, the relieving word I will check up, my lord. Because the honorable my lord, your 226 did not entertain because we submitted because of there is a
violation. Not clear from that order.
Just
the order, we cannot go behind the back of that order.
Your lordship, kindly see the page page 28, your lordship.
Page
28, my lord. Which I stated this is violation, your lordship. Before that, page 27, your lordship. Page 20, sorry, my lord, annexure 6, my lord. Page 27, your lordship. Page annexure 6, your lordships. Your lordship, they have passed an order with reference to subject intimated that the letter, this is the penalty order. Subsequent letters, subject were withdrawn, my lord. So, they have withdrawn, my lord. Thereafter, again, they have imposed, my lord, after that court order, my lord. That's why I'm saying this is a violation of court order, your lordship.
Yes.
They have withdrawn, my lord. The annexure for page 23 is the demand order, High Court order, my lord. Your lord, page 23, your lordships. So, page 23, if you I'm sorry for troubling your lordships. Annexure 4, page 23, your lordship.
Yes, we remember.
Yes, lordship. The reference, as per order of Honorable High Court, they impose a penalty, my lord. This, my lord, by letter number 21/9/2023. My lord, thereafter, your lordship kindly pay annexure 6. I have shown.
No contempt.
No.
That is our decision. That will go against.
My lord,
us.
the order, my lord, then, my lord, your lordship can, the order is say that it will discharge from the increment from the part of discharge from the penalty, my lord. Similarly, your lordship page 27, which I am stating the violation, your lordship can, subject to your lordship consideration. Page 28, your lordship. They have withdrawn High Court, Honorable High Court order. They pass another order. Your lordship has seen the annexure 5 and 6, they withdrawn after court order. They pass another order, page 28, your lordships. Revised order for recovery in obedience to order of Honorable High Court of Odisha. Notice that by the office number is hereby rectified and revised. The court said that relief from the increment, my lord. The word is relieving. This is not relieving, my lord. They hereby rectified, and then after your lordship they have.
Why did you withdraw? See, what will you get in a contempt proceeding? What can you get? Can that order be paused in contempt proceeding?
No, my lord. But this violation.
We can punish them. What will you get?
Look, they.
But these are two aspects, and you withdrew your writ
Yes,
petition.
my lord, I have discussed. My lord. The thing, my lord, I have failed, my lord. I submitted that.
We have our limited jurisdiction.
Your lordship, the withdraw because of this appropriate forum, my lordship.
We
Because this
don't
is
know.
the liberty, your lordship, page 30, your lordship.
Look,
Page 30, your lordship.
sorry,
Yes, your lordship.
in the present contempt petition, the petitioner has alleged deliberate disobedience of an order passed by a coordinate bench of this court dated 24/8/2023 in WPC number 8062 of 2019, operative portion of which reads as under paragraph 9. Paragraph, where is paragraph 9? Paragraph 9. So, it is not in dispute that subsequent to the said order of this court, that in the light of the said order of this court, the executive engineer RW Division Puri withdrew the office order by number 5974 dated 21/9/2023 and subsequent letters in that regard. To stop, after having withdrawn the said office order dated 21/9/2023, that was under challenge in that writ petition, which was under challenge in WPC number. Challenge in WPC number. WPC number
8056 of 2024. Annexure 8, page 30, lords.
23. 80569. What is the earlier writ petition?
Earlier, your lordship, that is WPC number. 8062
of 2019.
8062 of 2019. The executive engineer passed another order dated 13/3/2024 in compliance of this court's order dated 24/8/2023. So stop. The said revised order for recovery of penalty issued through letter dated 13/3/2024
was challenged by the petitioner by filing a writ petition giving rise to WPC number 8056 of 2024. Stop. The petitioner withdrew the said writ application after some argument with a liberty to pursue his remedy before appropriate forum. Stop. Learned counsel appearing on behalf of the petitioner has argued that there being specific observation made by this court in the order dated 24/8/2023 passed in WPC number 8062 of 2019 that the opposite parties of that case were required to rectify their mistake and revise the order impugned by relieving the petitioner from imposition of penalty. So far as package number OR 26-145 was concerned. Stop. Learned counsel for the petitioner has submitted that despite the said observation, the petitioner has not been relieved from the penalty imposed and accordingly the decision as communicated through later dated 3/4/2000 or
Yes, 3/11/2023.
4/4. 4/4/2024.
And 4/4/2004
sorry.
is, sorry,
You're right. 13/3/2024 is in teeth of this court's order dated
24th August 2023.
24
August 2023.
23. So stop. Next. After passing of the order dated, after having heard learned counsel appearing on behalf of the petitioner and the contemners, we notice that after passing of the aforesaid order dated
13 March 2000.
24/8/2023, a decision was 3, the contemners had recalled earlier order dated 21/9/2023 was stopped. The 23 and subsequently a revised order of recovery was passed as communicated through later dated 13/3/2024 was stopped. In contempt proceeding, we need not go into the correctness or otherwise of the said decision. So the petitioner himself had questioned the correctness of the said decision by filing a writ petition, which he had subsequently withdrawn. Stop. In our considered view, comma, in our considered view, the no case of willful disobedience of this court's order is allowed. The facts and circumstances of the case, the contempt proceeding stands stopped.
The petition may be liberty to.
Liberty, how can we give liberty? That
It's
liberty.
it's
you can
already
give-
there.
Yes, Mister, that is the response.
I'm sorry, my lords, I was not
Yes.
present, but item number 28 was called out.
Yes, that has been complied with.
My lords, that has been partially complied with, not fully, my lords. I demonstrate before your lordships. Your lordship direction was to calculate and pay. Now they say, my lord, we have calculated it, our job is over. So they don't emphasize on the payment part, my lords. If your lordship, since your lordships are rising.
Payment has not been met.
No, payment cannot be made by me. Payment has to be made by the accounts, sir, because pension
But your
and other
lordship-
things.
Just
I'm-
How can, the DO cannot pay the pension, lord. Now he has calculated, recommended for pension to the pension authorities, lord. Now PPO will be sanctioned and the amount shall be paid, my lord.
So your lordship may call it,
Please talk to him.
Yes, lord.
your lordship may call it after vacation.
We will see.
Item
After vacation, because 2
In the
PM. my lord.
meanwhile, please ensure that the PPO is to be issued by the Accountant General's office.
Right, my lord.
So, it should be done.
No, that is under the, my lord, so I think accountant general is not
appears for that. Mr.
government of
Patra-
India, that he is
Yes,
not,
Mr.
AG is
Patra
party
appears.
or not?
no.
No, AG is not a party, but your lordship's direction was 8 weeks, calculate the amount and intimate to the petitioner. 12 weeks, my lord, make the payment.
So they cannot pay.
My lord, at least, my lord, an effort has to be made, my lord.
Where is the question of effort? Will they go to the office of the Accountant General?
No, my lord,
See,
accountant,
you were seeking payment of pension.
my lords,
Accountant General is a necessary party in all such cases.
my lord,
You did not
my
implead.
lord, after, my lord, I was, essentially, my lord, my order was for payment of back wages. This was, my lord, challenge and writ appeal.
Payment of back wages has been made or not?
No, my lords. But what has happened, my lord, in the writ appeal, the lordships held, my lord, that no, it can't be done. It has to be construed from the date of acquisition of trained graduate qualification, notionally, and it has to be, the pension amount has to be recalculated and paid, whatever is there.
So pension amount is another
So,
aspect.
my lords, so my adding this accountant general as a party, my lord, in the writ petition never arose, my lord, because that was not my case. That only cropped up, my lord, after the modification of the order of the single judge, my lord, and the writ appeal. My lords.
Mister, when you were claiming pension or not in your writ petition?
No, my lords.
No.
Because at that time, my lords, I was claiming, my lords, give me the back wages.
Very good.
In the meantime,
So if you are not claiming pension, then they are not required to pay pension.
what has happened, my lord, in the meantime, he retired. Then, my lord, when the matter was transferred after the abolition of the tribunal to this honorable court, my lord, the single judge, my lord, honorable single judge, he passed an order. That was modified by your lordships in the writ appeal, saying, my lord, that back wages are not allowed. Notionally, it has to be calculated and the pension has to be recomputed. That was the order of the writ appeal, my lord.
They have recomputed.
They have recomputed, my lord, in my humble submission, my lords. There was a specific case, my lord, if your lordship would kindly permit me, as per the revised scale of pay, I was supposed to.
Was there any direction for payment of
My
pension?
lords, my lords,
Where is that?
my lord, paragraph 6, my lords.
Read it.
I'll read it, my lords. The pension reworked. My lords, may I just place that paragraph?
Yes, please,
The
please.
pension reworked thus will become payable to him from the date of his superannuation. The said calculation is to be worked out and the appropriate orders issued by the appellants within a period of 8 weeks from today. As far as the areas of differential pension is concerned, it shall be paid to the respondent within a period of 12 weeks.
Yes,
So there was a direction both for calculation
Yes.
as well as payment, my lords.
they cannot pay.
That's the spirit of your lordship's order. my
Where
lords.
is the spirit of if the accountant is not a party, then the order cannot be complied with.
But at least some efforts.
Unless the accountant general issues this PPO, you cannot.
Lord,
pay.
this, my lord, this was to be complied on 15/5/2023.
Right.
Nothing happens till 2024.
All right.
Lord, after a year's
All
time,
right, we will see, because he is a retired employee, we will see, but this is not the way the case is conducted. This case on 24 June. So, in the meanwhile, we expect the contemners to inform as to whether the office of the accountant general has issued the authorities
Item 74, sir.
May it please your lordships. This is that Transport Department tender. And regarding that Form S, which had a particular declaration, and your lordships were of the view that it is restrictive. My lord, we have filed an affidavit today, and if my learned friend wants me to go ahead, I'll start arguing this.
This is a copy. I think Mr.
Mr. Mishra has joined. Mr.
No,
I'm here,
Pinnacle.
madam. I'm here.
He has joined.
May it please my lords, madam.
So, my lord, we have filed an affidavit today, and I'll come to that affidavit. Actually, I wanted to ask them that where did you get this clause from to begin? And if my lords are kindly pleased to, my lord, turn to annex page 10. Page 10, my lords. This is National Aerospace Laboratories. My lordships have it.
Yes.
And my lords may kindly turn to page 16.
Page 60,
16.
16.
At the last paragraph, my lord, we hereby confirm and declare that we, Messrs. So and so, do not have any litigation, arbitration history with any government department, public sector undertaking, etc., etc. My lords have it.
Yes.
Now kindly turn to the next one, page 19. It starts at page 17.
Yeah.
Page 17, my lord, and if my lords are graciously pleased to kindly see, my lord, page 19. There is a similar clause.
Yeah.
And my lords may now see page 20.
Yeah.
This is another Government of India organization. And the relevant page is at page 22. Lord, it appears that the consultant has relied on these, but let me tell you, lordships, none of these clauses have been tested in any court of law as to whether it is arbitrary, good, bad, indifferent. Now, if my lords are pleased to turn to my affidavit now, at paragraph 7, my lord, our concern is that this is a time-bound program, and I have to have these automated testing stations. If my lords are pleased to see page 2, my lord. Page 2 of my affidavit today. These automatic testing stations have to be in place by 1st of October 2024.
Yes.
And therefore, my lords, this is a statutory date, and I have to install 21 of them. Now, paragraph 7 at page 3, I have tried to find a solution to the problem.
Yes.
The solution is this, my lords. If your lordships kindly permit us,
Yes.
and if I may say so, my lord,
Yes.
issue a direction, we could issue a corrigendum deleting this Form S and give 10 days or 12 days or 14 days for people to participate.
That can be done.
That should solve everybody's problem. So my tender is not derailed. People come in and participate. Only thing is, I will seek your lordship's direction on this because there is a code of conduct now going on. Under the rules, the officers will find it difficult. So your lordship may say that in view of what I have said in paragraph 7, may I read paragraph 7 for your lordship's kind consideration? That without prejudice to the aforesaid submissions, it is humbly submitted that the opposite party, your lordship may delete willing, that's not right word, to allow the other available bidders, because that was your lordship's concern. So many people have been left out.
No, but
Now
we
it
can
has
do
been
that.
opened.
We can do that.
Yes, my lords.
But the difficulty is
Yes, my lords.
that if we pass any order
Yes, madam.
in the absence of someone
Yes, my lords.
who has been declared successful.
Well, nobody has been, the bid has not been opened.
No, the technical bid.
Technical bid also has not been opened.
No, he He's there.
Technically, we have
Technical bid has been opened.
Open. Technical bid
My
has
lord,
been
he's
opened.
there.
Technical,
One
he is there for one.
Yes, my lords.
So two have been found to be responsive.
Yes, my lords.
So out of the two, one is
My
there.
lord, may
I've
I?
been ousted. I have been ousted, my lord, because of the clause.
No, you are
We
already there in
understand.
court.
We understand. We are trying to solve it out. Mr.
Yes.
Grateful, my lord.
My lord, I would most respectfully submit, my lord, we will take, let us also put them to notice. Because if I start again,
No,
afresh,
you may put them to notice. The only difficulty is there with the court.
no,
If we will permit you,
Yes.
that we can do.
yes,
And if that serves your purpose, it's we shall not comment upon the legality or otherwise of
Fair
those
enough.
clauses.
fair enough.
All right, we
Yes.
will permit you, and if that serves your purpose, based on that, you can
I give them,
without violating the
I
code of
upload it at my portal, give them 10 days for anybody else who wants to participate, and then go ahead. This is one way of looking at it. What fell from your lordship is that there are other two parties who are not before us.
one of them is
One of them is there. The other one, if my lord service notice is taken by special messenger, or we try and inform
no,
them,
you can do that.
I can do.
See, you doing that, no one may have any any objection to it.
Right.
But if we pass an order,
My lord, I quite see that. I quite see that somebody will challenge it and say, in our absence, how could such an order be passed? Fair enough.
so we can just give you liberty. If you want, you can do. So that is only for the purpose of meeting the restrictions of code of conduct, model code of
My
conduct.
lord, may I suggest this, subject to what falls from your lordships? There is only one person who is left out, am I right?
One person.
One person. Today we are on Thursday. We will try to, either your lordships will issue a notice by special messenger or to be spent by speed post, email, whatever. And if he comes and appears and fix this case to Monday, in his presence, the order can be passed. So it solves everybody's purpose.
I don't have an objection, my lord. I
Yes, do
think
you
this
have?
is-
Are you in touch with him?
No.
My lord, I have one caveat, my lord, if your lordships don't mind. My lord,
Yes,
the learned advocate general, my lord, is an unexceptionably honorable man. So, my lord, I state that at all times to his face and behind his back. The only problem, my lord, is that his officers who have couched this para 7, would your lordship kindly see, I only hope it's not disingenuous, because para 7 says, without prejudice to the aforesaid submissions, it is humbly submitted. OP3 is willing to allow other available bidders, players in the country as stated above, to participate in the present bid by deleting clause 23 for the said new players bidders. So clause 23 only gets eliminated for the new players bidders by issuing appropriate notices. Now kindly see the next sentence. Such a step will not affect the bidders who have participated in the present tender, and it will only be for new players bidders. But I just hope that I am clearly ousted on account of clause 23. I hope it doesn't mean that it will only, my lord, not apply to new
My lord,
bidders.
let me upfront tell my friend that 23 will not apply to anyone, because once we are deleting it. And I have a second submission to make. My lord, who am I? I represent the government, and the government is right there.
No. My learned friend is always disingenuous again, my lord. Now he is, this left-handed thing doesn't work, my lord, with great respect, my lord.
So therefore, my lord,
We are before your lordship.
Therefore, my lord, may I most respectfully submit. Mr. Pishra's point is well taken. If others are not to be affected by 23, how can he be affected by 23? It's point well taken. Your lordship may say, okay, come on Monday.
His difficulty is different. His difficulty is that that clause will not apply, but you have already.
That's right.
Lord, we are before your lordships. Lord, we are before your Lord, we are before your lordships. So I was only requesting if my learned friend would take notice by special messenger to the other respondent, to the other opposite party, then and we'll try our luck on Monday.
But,
If he-
can I
if
have
they
a
appear-
say, my lord? with permission of Mr. Pinaki Misra and the Learned Advocate General. But both are quite respectable, in fact. And they are really respectable in the sense they keep their words, my lord. But what I mean to say, if your lordship reads the
You are reminding them that they always.
so one clarification I need, my lord, with I think Advocate General is gracious enough to accept it. Sir, I have been ousted with a technical point that GST amount has not been added.
Let us see what happens.
Yes, we'll see on Monday.
Have
Just 1 second. GST amount has not been paid. Now they're extending the time. Am I clear for others to participate? But we have already deposited that amount 2 days after. That is 18th, 20th, we have deposited. But GST is to be counted at the end of the month. But that should not be a ground.
Let us get rid of 23, we'll see the next one then.
Right. That is exactly. I think I have put the word with him. He is gracious enough to accept it, I think. Not to throw me out.
As I said, the Learned AG always has the interest.
That is for your lordship to decide. Let us come on Monday. Let us get rid of 23 first.
The Learned AG always has the interest of the state at heart, the state's revenue at heart, and the state's best interest at heart. I have no doubt in my mind.
I'm in the word on that because
you will do justice. I have no doubt.
As far as this clause 23 is concerned, that's of course something which is new. As your lordship saw across the country, these clauses are there, but no court has actually ruled on that. Apart from that, so far as the petitioner's rejection, that is on a completely, it's annexure 4, the tender conditions prescribe that. So if, then that would amount.
the easiest course for court is to set aside those clauses
23.
and direct for fresh tender, irrespective of the consequences, because that is as important as the other provisions are. This is one, and therefore we were giving an opportunity to the estate to rectify it.
Right.
So if something can be done, it's all right. Otherwise, we are there.
No. Therefore, I was saying, Melons, the issue which we are stuck on 23 because one person is not here.
No, because we could have dismissed the writ petition. We were thinking of dismissing the writ petition also on the ground that an essential condition was not
The other one. Yes.
So on that ground,
Correct.
we could have dismissed.
Fair enough.
But even while dismissing that the case of the petitioner, we could have interfered with the process of the entire tender process.
Correct.
Because of that clause.
So 23, therefore, my lords, therefore your lordships are right that 23 does not appear to be reasonable. Arbitrary, and your lordships wanted that 23 should be interfered. So I am giving a counter proposal.
Right.
That since there is a time bound, originally another
We understand.
because it has to be done by a
Statutory.
particular date.
Yes.
I was only seeing whether we can salvage anything out of it.
Right.
So therefore, my lord, I was saying that we will take notice on the other respondent and come back to your lordships on Monday. If he also has no objection to this proposal of corrigendum and 10-15 days notice, I think that would solve the problem.
That can be done.
My lord.
Issue notice. Special, how to? Can it be through email?
My lord, may say email and through
Email special messenger
Where is he?
to the non-appearing opposite party number.
OP number.
would be OP number 4,
OP number 4.
Pune in Maharashtra.
Lordship may say email because special messenger going and coming will take 4 days.
Special, where is he? Where is the address?
Pune in Maharashtra.
Maharashtra.
Email.
Pune. Email. Not indicating therein that the matter will come on Monday so that they engage a lawyer.
Monday to be taken up at 10:30.
10:30. Great.
10:30.
Great. Right.
And just, my lord, 15 seconds, my lord, your lordships
Yes.
will kindly remember, my lord, my argument on the so-called GST infraction. That, my lord, is a completely non-essential clause, my lord, and your lordships, my lord,
Cannot forget, Mr. Mishra.
I'm so grateful.
With reference to division bench decision.
I'm grateful.
Chief Justice Vinny Saran, my lord, has passed judgments on this.
We do remember.
I'm very grateful.
Regarding the GST, I'm yet to submit. So I will be submitting my submissions regarding the petitioner's rejection. Because I have not yet completed. In fact, midway only this clause 23 came up.
Lordship, a hearing on Monday.
We'll do it on Monday.
My lords.
Very well. Deeply grateful to my lords. Grateful to my lords again.
So there would be two issues. 23 is one. The other one is 2.9. Which
If you succeed on 23, then only we are required to deal with the other.
Yes, my lords.
23 more or less we have agreed unless the gentleman who will now come and disagrees.
My lords.
My
Grateful.
Notice will go through court. Just give the email address ID.
Yes, we will. Yes. I think they can give it.
Item number 42.
Mr. Behra, can you have a talk with
Official.
that party
Since
over
OP4 is a
phone,
participant,
over telephone?
my
Just
we may
intimate
communicate.
that certain brief has been
Yes.
posted to his email
That
so that they can,
yes.
otherwise they will say they have ignored or they could not view it, or
My
they have to understand what is
Right.
that.
Otherwise, the problem is that we may have to stay the entire process. So instead of staying the entire process, we intend to
Yes.
keep
I
it
will
going.
intimate and I will provide the mail ID to the counsel for the petitioner also.
Mail ID to registry.
Yes,
Registry.
before the registry.
So lest they may skip over, so you have a talk with the client that certain
Lord, all
materials have
endeavor I
been,
will take.
certain materials have been posted through Odisha High Court
On Monday.
for the, for doing the necessary.
Oblige.
Item number 42.
Just. What is appearing?
Item 42.
Mr. Bhuyan.
Contempt.
Sincere plate upon the
versus Hitco. So
There is no representation on behalf of the petitioner. This matter on Monday.
Item 43.
There is the non-compliance violation by the
Which order?
Annexure 1 at page 14, my lord. Relevant page is page 20, paragraph 11. Thus, having interaction with the counsel for the parties extensively, we accept the claim of the applicant Mata 38 to the wife, and we settle the permanent alignment 80 lakhs to be paid by the appellant Mata 37 of 21. The appellant of Mata 38 shall receive the amount that has been invested in the State Bank of India in the name of Registered Judicial High Court of Orissa. The remainder of the amount, that is rupees 50 lakhs, has to be treated as outstanding, and that amount has to be paid by the appellant of Mata 37 of 21 in two equal installments. First installment of rupees 25 lakhs shall be paid within a period of 3 months from today, and the final installment of rupees 25 lakhs shall be paid within a period of 6 months from today. Though the opposite party is not been paid in the meantime, during the specified time, but he has paid 70 lakhs, 78 lakhs. And the next page, my lord, page 21. The next page 21, paragraph 14, my lord.
What is material? Mat A.
Next page, kindly, my lord, turn to the page 21, paragraph 14. It is made abundantly clear that no further maintenance allowance the appellant of Mata 38 of the 21 shall be entitled to in terms of the order passed in criminal miscase number 550 of 2016. Even no area outstanding amount shall be claimed by the appellant Mata 31.
From domestic violence. It has, judicial magistrate has passed the order.
Right.
So thereafter, judicial magistrate passed under Domestic Violence Act.
So,
Thereafter, it has,
the land
appeal was-
and family just passed the order and
Permanent.
allowed to decree of divorce and permanent alignment 50 lakhs. That has been challenged before this honorable court in matter. In paragraph 14, it specifically, in failure of default, its clause is there.
So
Even the
this is
Right.
execution of an order. This can be outside. Execution. Execution of an order. So how contempt will lie, Mr.? It's a case
Yes.
of execution of a decree.
There is no, it's a arising out of matrimonial appeal, my lord.
So matrimonial is a
specific-
continuance.
If a specific order is there, in the event of default of payment in terms of our direction, the said compensation amount shall be paid by the appellant of matter 37. Where is the upper line state? I'll only with the permission.
No, Mr. Counsel, the question is whether such order is to be executed by the court or not. There shall be an execution proceeding. How contempt?
Contempt can lie, my lord.
Difficult.
If any deliberate disobedience of the order passed by this honorable court, then the cost must be punished in contempt. There is a decision, my lord.
So in case of any decree passed by the
Well, any
civil
judgment and
court,
order, my lord.
civil court, contempt will lie.
Yes, my lord. Yeah. Referring to also apex court, the Delhi High Court has been, say this contempt is maintained. It's a similar case out of the DV case, my lord. Out of the said matrimonial case. Referring so many honorable apex court. At paragraph 18, she classes to the flowing from the above judgment, it appears to this court that scant disregard must be shown towards the order of the court to establish willful disobedience, so as to make out civil contempt under section 2B of the 1970 Act. If such willful disobedience is observed, then the court must take cognizance of its such contempt undermines the dignity of the court and outrages the majesty of the law.
And your earlier contempt petition was dismissed.
No, my lord. Earlier contempt is the opportunity to extend within time at page 48, my lord. Let the opposite party comply with the same, if not already complied with in time, within a
Yes,
period
sir,
of
okay.
3 months from the.
All right, we will see this later. Issue notice.
Keep looking.
We will examine that aspect.
May I please? If non-compliance of order dated 1/2/2024, your lordship, operating part paragraph 5, page 17, your lordship.
Which page?
Page 17, your lordship.
We were under the impression that in all your cases, the orders have been complied with, in which you are appearing. The opposite parties may be scared of you.
Different.
Oh,
Here, your lordship,
they don't know you.
BMC.
It is because they don't know you. All right.
Yes.
Yes, what is the operative procedure? Yes, what is the operative portion?
That is paragraph 5, your lordship. Considering the submission made on behalf of the petitioners in not requiring adjudication, we are not inclined to direct issuance of notice on opposite part number 3 and 4. Instead,
in event petitioner make fresh representation enclosing this order, said opposite parties will be deal with the same within 4 weeks. Thereafter, I have submitted representation that is annexed to your lordship.
There is no direction, mister. We should not deal with the same within 4 weeks.
My lord.
Who had to implement? Who had to pass an order?
Milord, I have instruction from the Municipal Corporation, to extra copy be sought. So that because the only direction was for disposal of the different. What is the state that I can submit that? And no notice was issued. At the time of application, no notice was issued. Only direction was let them file a fresh application, which will be considered in accordance with law.
Thereafter, we have filed a fresh representation that is annexed to page 19, your lordship.
Mr. Niranjan Panda 1 accepts notice on behalf of
Yes, yes. Yes.
accepts notice on behalf of Bhubaneswar Municipal Corporation.
Mal. By tomorrow, your lordship. By tomorrow, your lordship.
What?
Extra copy, your lordship. I will
By
sort
today?
Mal.
In course of the day, do it in course of the day.
Oblige, your lord.
We complete a requisite number of the copies of the application. Be served upon him in course of the day. This case after summer vacation. So as to enable Mr. Panda to inform this court about compliance of this court's order dated 1/2/2024 passed in WPC number 1372 of 2024. Yes. For orders item 45.
May kindly come to case 47.
Yes.
My lord, there was only direction for consideration of the representation, my lord. We should not have filed the writ appeal. My lord, may kindly pass.
The present intra-court appeal has been filed against an order dated 22/2/2022 passed by a learned single judge of this court in WPC number 5093 of 2022. So stop. By the aforesaid order, the order learned single judge had directed the opposite party number 2 has directed opposite party number 2 to consider the petitioner's representation and pass appropriate orders in accordance with law. Stop. Considering the nature of the order passed by the learned single judge, we do not find any merit in the present intra-court appeal, which stands dismissed. Interlocutory applications, if any, stand dismissed. Item 46.
There is a delay of approximately 20 days in filing this with the results.
Allowed.
That may
Who is for the other side? Who is for the other side?
Here for SBI, it's a fresh matter. I'm for the petitioner.
All right, issue notice. No, for the appellate or petitioner?
Well, applicant.
Issue notice. The point of limitation. Yes, item 47.
File requisites.
Requisites. Which case?
47.
47. 47.
And in this case, I'm appearing for the sole opposite party matters. I filed in application to the IA for condemnation of delay matter. Yesterday, I filed in the counter. That is not on the record. Therefore, I pray this matter to be taken up when it after vacancy.
Yes, Mel. If he has filed an objection,
Is stated by learned counsel for the respondent that it is there. What is the delay?
And-
690 days.
no. In fact, it is correct to some extent. This order was passed on 15/9/2021. Instead of challenging it in writ appeal, a SL was filed before the Honorable Apex Court. Clerkship page 78 in the order. That
SLP was filed when?
SL was filed date in 2022. That number is 39433 of 2022. That was disposed upon 22/8/2023 with liberty to file a writ appeal here. So this was disposed upon 22/8/2023. And we got the copy on 28/8/2023, filed on 11/9/2023.
Yes, we can cut down the delay.
Bypassing an inter-court appeal that directly approached on the Supreme Court.
Strongly.
In SLP minutes. And one more submission minute, the SLP has been dismissed with liberty to approach the honorable court, but the delay has not been condoned. That is no reason.
They were pursuing their matter in wrong forum.
Wrong.
IA number. The registry has pointed out delay of how many days?
97.
97 days delay in referring the present intra-court appeal. So, this application has been filed for condonation of it. So, an objection has been filed on behalf of the contesting respondent to this application. So, next then is AGA appearing for the appellant has submitted that the state had preferred an appeal before the Supreme Court against the order dated 15/9/2021 passed by the learned single judge of this court in WPC number
20003 of 2020.
2003.
Yes, my lord.
2003
My lord. Of 2020.
of 2023.
2020, my lord.
2020. Of the said SLP, however, came to be dismissed. Came to be dismissed.
Yes.
By an order dated 22/8/2023. With a liberty to the appellant to assail the impugned order of the learned single judge before division bench of the High Court. So, accordingly, the present inter-court appeal has been filed on 11/9/2023. So, he submits, learned AGA submits that it is because the appellant had chosen a wrong forum that the present appeal could be filed much after the order which is impugned in the present appeal was passed. So, he submits, however, that soon after the appeal before the Supreme Court, the SLP was dismissed by the Supreme Court on 22/8/2023. The present inter-court appeal came to be filed on 11/9/2023. So, he submits that delay, if any, in the present in filing of the present inter-court appeal is not intentional. So, next, when counsel appearing on behalf of the respondent objecting to respondent has on the other hand submitted that the appellant had chosen a wrong forum to assail the impugned order passed by the learned single judge. So, secondly, the Supreme Court, while granting liberty to the appellant, did not condone the deal. So, after having considered rival submissions advanced on behalf of the parties, the court is of the view that it is apparent that because the appellants were pursuing their remedy before the Supreme Court by assailing the order dated 15/9/2021 passed by the learned single judge, that the present appeal has been filed belatedly after disposal of the SLP by Supreme Court on 22/8/2023. So, stop. We are satisfied that that bona fide reasons exist for delayed filing of this appeal. Stop. Accordingly, this application is allowed. The delay stands condoned. Just for admission. That's after vacation, it will come for admission.
Item 48.
Three days delay condoned. Yes,
I am for the respondent.
all right.
Only notice was issued on limitation. The delay will condone.
Condone.
A copy will serve to more, us to the
Sir.
appeal memo.
Sir,
So that I'll have this.
all right. Admission.
Item 49.
Okay, sir.
Item number 40.
49, notice to 60 days delay.
Notice.
Item 50. Item 50, there is a limitation. Regarding this is the rehabilitation matter, but there is a limitation of 400 days.
Which is matter, rehabilitation matter?
Yes, madam. That is that Malayananda city case. Notice may go on the question of limitation.
Can we? What are we doing? I forget. What are we doing in such matters?
In fact, I have gone through
What
that.
are we doing in such matters?
Will also be issuing notice on the question of limitation. In fact, I have gone through this brief, my lord, what has happened, though it has been mentioned as it will be covered under Malayananda city case, but that case is covered under that Ajit Berry case. Your lordship know that Ajit Berry rule 2B has been interpreted that any member of the family preference. Lordship may issue notice on the question of.
Instead of preferential.
Yes, madam.
First, second or third.
Yes, madam.
Let us read.
The question of limitation.
Point of limitation.
Son,
Son,
mother,
mother
after death of
became
her,
incapacitated.
death. First, may issue notice on the question of limitation. When that matter will come, I'll place.
No, but if there is no marriage, then why should we issue notice?
In fact, I am.
That's why it should. Item number.
Lordship, why I am saying because it has been decided on the basis of that Malayananda city case. So if that matter will be decided on the Malayananda city case, after that, because all the matters are before the Honorable Apex Court in that Malayananda city case.
No, Malayananda city has not been
Has
referred
no
to.
nexus with this case.
Malayananda city case is of Odisha High Court,
Yes, and
confirmed in Supreme Court.
this case has no nexus with that Malayananda city. That ratio decided in that Malayananda city case. That's why I'm submitting that you'll also issue notice on the question of limitation.
Issue notice, we may issue notice, but we are issuing notice to whom?
Yes, madam, that I understand.
Here perhaps you are taking a plea that he was an work charged employee, died in harness.
Yes, even
So,
even
the
that work.
son could not be
Yes, ma'am.
rehabilitated, but you have delayed.
Then may I
Slowly
claim-
paid
We are
the
just
employee.
dismissing it on limitation,
Ma'am.
the point of limitation. That is
Yes, ma'am.
just- Year number 8722.
My limitation.
8722.
23.
8722. 8722.
8722.
Flag B.
This application has been filed for condonation of delay of 400 days.
My lord.
400 days. 402 days.
Fix. I have 406 days for
412 days.
412.
12 days in referring the appeal. To stop the state of Odisha by the impugned order passed by the learned single judge. The opposite parties have been directed to consider the claim of the respondent for appointment
Yes, ma'am. For consideration, your lordship is page 21, my lord.
Yes, yes. Appointment what? Consideration of his case?
For appointment under rehabilitation assistance scheme.
Odisha Civil Services Rehabilitation Assistant
Rules
Rules
1990.
1990.
For his appointment under, just give the,
Odisha Civil Services bracket Rehabilitation Assistance bracket Rules 1990.
stop. As which post? Post one.
Group D. It will be Group D.
Group D post.
Group D.
Against Group D post. Stop. After having carefully gone through this application, we find that except for vague statement of movement of the file in the department, there is no valid reason for this court to condone delay of 402 days, particularly as the controversy relates to the appointment of a respondent of the respondent against a Group D post which has been directed to be considered by the learned single judge by the impugned order, in accordance with law. This application is accordingly dismissed. So consequently, the writ appeal WA number so and so also stands dismissed. Yes.
Item 51. My lord, item 51, these three matters, my lord, remember that my lords have already heard WA 687 of 22, that qualification, certificate matter. So these three matters are to be taken up after judgment of that.
All right.
WA 687 of 2022.
WA
687 of 2022.
list these matters on after consideration.
Item 52.
So
You have delayed. 378 days.
we can condone delay in cases of the state of Odisha, but how can we condone such delay in your case? All right, what is the explanation?
If order passed on 19th November 20.
Ignorance of law.
My lord,
Ignorance of law.
my lord. He is filed one application before the High Court Legal Service Committee, and Legal Service Committee engaged to me to file writ appeal as such a delay.
You are in the panel. You are interested with this
My lord,
by the
Legal Service.
You are appealing.
Opposite party on school and mass. Opposite party is school and mass.
They are appearing. Now there is no school and mass education separate panel.
Who are you? What is your status? This.
PET.
Intra-
PET.
Sir,
You are approaching for PET.
My lord, PET, my interval time of 1997,
Physical
my lord.
education instructor.
Is filing is SCB certificate, my lord. Is SCB certificate, without SCB certificate is not considered any PE teacher. He is more than, mark is more than
The
second applicant, my lord.
there is a delay of 346 days
My lord.
in preparing the appeal in the present intra-court appeal. Stop. It has been stated that the appellant was unaware of the legal position and he suffered from the paucity of fund to pursue to prefer an appeal against the order passed by the London single judge. Stop. He accordingly moved the High Court Legal Service Committee to engage a counsel and accordingly the present appeal has been filed. To stop. We have heard learned counsel for the appellant and learned AGA for the estate. To stop. In the background of the facts disclosed in this application, a case is made out for condonation of delay in preparing the appeal. This application is accordingly allowed. Delay stands condoned.
Item 53. Item 53. My lord is a party to that order. My Lord Justice Raman is party to that. Lordship, page 37.
Let us be placed before and let this matter be placed before an appropriate bench of which one of us bracketed MS Raman J is not a member. Did
Item 54. Item 54. There is a delay of $352. My lord, similar matter. This is the regarding that RACP. Similar matters have been stayed before the Honorable Apex Court. Some matters dismissed on the ground of delay and some matters on merit. Many matters have gone to the Apex Court. Honorable Apex Court has also stated that. May I pray, my lord, your lordship, because that issue is pending.
issue not, we can issue notice.
Well,
They're not doing anything, just delay. Yes.
55.
Please, Your Lordship. Lordship, there has been a delay of 55 days, Your Lordship. Please.
Condoned.
Lordship, another IA has been filed. Lordship. IA number 570 of
Let it come for admission.
Please, Your Lordship.
Item 56.
56, my lord, I am for the respondents. I have already ready with the objection to the condonation of delay. I will file, my lord, so your lordship may
put it after vacation,
How much did?
271 days.
Think for the estate.
No, no, after disposal of the content petition, they have filed this. And I have explained everything in the objection, so you also may put it after vacation, so it can be taken up.
This case on after vacation first enable learn counsel for the respondent to file an objection to the limitation petition filed on behalf of the appellants.
Item 57. 57, my lord, this is regarding the headmaster scale of pay. Number of cases your lordship has issued notice
Yes.
on the question of limitations. They didn't fixed. There is
Fixed the hearing of those cases.
a batch of cases are there. Batch of cases are there my lord, regarding that headmaster scale of pay during that officiating period. And a number of cases your lordship has issued notice. So there is limitation on the question after reopening one. In each case, your lordship has issued notice on the question of limitation. This
169 days delay.
yes,
We are no issuing.
well,
Yes.
from 58. 58, no, there is also delay, my lord. Your lordship may I pray, your lordship may call this matter next week. Why a similar matter has been disposed of? I have to verify it.
As requested. This case on Tuesday.
Well, my lord. Item 59. May item 59, my lord, I am for OUT, my lord. 21 days delay. My learned friend is appearing.
Respondent, my lord. A copy, let me serve a copy, my.
21 days. 21 days delay.
Give him copy.
Yes, madam. I'm serving it.
Running.
51. 51.
51.
12/1/24, date of judgment. You presented it on 2nd April.
Well, 51 days delay.
We wanted. Yes.
From 60.
60, my lord, has heard the matter on Monday. That my lord has orders reserved.
Which matter?
That my lord, promotion from 89.
But notice will have to go. How many days?
Notice, my lord, 4 or 60 days.
Notice.
Item 61.
Just to remind my lord.
I am sorry, I am the virtual mode, my lord, because my lord, I have received an instruction from the ministry. They have given instruction that the 5 dates has been given to them: 22/9/2023, 23/2/2023, 12/3/2023, 2/4/2024, and 3/5/2024. And the last date was 3/5/2024. None have filed the rejoinder, no instruction again. We have given the time and we have extended. This is the instruction I have received from the regional authority.
I have filed affidavit. I have also attached a copy of the email. All the rejoinders have been filed. That's my instruction. I have given that email along with the affidavit, though original affidavit is not affiliated to the record. But for my lord's reference, I have given a copy of that affidavit. Kindly see annexure 17, page 10. That those copies of those affidavits were for my lord's reference I had given.
No, I received the same. My lord,
Here,
I send it to the ministry.
in all these.
But on 10/5/2024, I have received the
The
instruction.
rejoinder is
Might
already
have
filed.
just filed thereafter.
Yes, it is filed.
On this, the petition was filed on 12/5/2024.
Yes, it is already filed, but that's not the issue. Issue is somewhere else. With regard to vacating the interim order on the, we just cleared the day counter was served on us. On the next day, we wanted to give us some time to file rejoinder. The revisional authority vacated,
yes.
that's the matter, lordship remembers. So your lordship was about to pass the dictating the order, wanted to see the lapsing order. So lapsing order I have filed. Lordship can see that. And in the meantime, we have already filed rejoindal. That's no worry. Lapsing order is at page 4 of my affidavit, man.
Mm-hmm.
27/2/2023 is the lapsing order. Against that, I had filed revision. Yes, ma'am. I was referring to Rule 36 of 2016 rules. 36(2). Let's see if I've been pleased to take note of that rules also. Rule 36(2) of the mineral other than atomic and hydrocarbons energy minerals concession rules 2016. My lords are having the book.
Yes.
36(1) is the matter regarding on receipt of an application, a revision under Rule 35. Copies thereof shall be sent to the state government or other authority and to all the implicated parties, calling upon them to make such comments as may they like to make within 3 months from the date of issue of the communication. And the state government or other authority, the implicated parties, while furnishing comment to the central government, shall simultaneously endorse a copy of the comment to the other parties. 2. Comments received from any party under sub-rule 1 shall be sent to the other parties for making such further comments as they may like to make within 1 month from the date of issue of the communication. And the parties making further comments and send the same to all the other parties. But here in this case, Lordship will see, so far as the state is concerned, they have taken time to file their reply from 22/9/23 to 26/2/2024. They have taken time to file their reply. Let's see, despite the rule provides that they have taken time.
No, what are the dates?
Beg pardon, ma'am.
What are the dates?
Acha, 22/9 to 22/9/23 to 26/2/24. 22/9 September 2023 to 26 February 2024. Thank you.
Yes.
Lordship, see page 34 of my brief. The Revisional Authority, considering all these aspects, was pleased to pass an interim order not to take any coercive action. That order was passed on 23/2/2024.
23
to 2024.
Yes.
On that very date, the matter was fixed to 12th of March 2024.
Yes.
On that date, Lordship sees 12th of March 2024. I am reading the placing the order. The case was listed for hearing today. The revision
No,
is
that we have seen. But in the meanwhile, what happened between 23 to 2024 to 12/3/2024?
There are 23 to 20 after 22nd, 23rd of February 24.
You wanted to file the rejoinder to what?
Rejoinder to the reply filed by the state.
Rejoinder to reply.
Reply filed by the state.
When was the reply filed?
Not reply filed, not very recently, we have already filed it. We undertook before my lords that we will file it. We have filed it, my lord. Here we file it. On 12th, my lord, 12th of May 2024.
12th of May. Oh, you wanted to file the rejoinder.
We have filed the further comments. Beg pardon.
You wanted to file the
rejoinder. I wanted to file rejoinder on 12th of March.
On 12th of March. But when was the reply filed to which you wanted to file rejoinder?
That was the, when was the reply filed, my lord?
You wanted to file rejoinder to something.
26th of February 24.
26th of
February 24.
What was filed on 26th of February?
Reply by the state, my lord.
Where is that? Is it there on record?
That reply is not on it.
That is not in dispute, Mr. Pari.
My lord, it is a case, not dispute, but it is a case where the state took time for which interim order has been given. That is on March, that is on 12th March 2024, 12/3/2024. Then the state has filed his matter is fixture of hearing. That is on 2/4/2024. No rejoinder was filed by the revisional authority and that took time. According, because the state was taken time, we have given interim order. The state is filed the petition, again you have taken time for filing rejoinder, for which the stay was vacated, he has given the date for argue the matter. It was
But it
fixed for
appears
argument.
from this order, Mr. It appears from this order
My lord.
that the stay was vacated only because
On
prayer was made for
12/3/2024.
filing rejoinder. Yes.
Yes, ma'am.
And he had a right to file rejoinder.
Yes, this rule 36 of clause 2 is provided, what my learned friend is said now. Let's me part necessary. As already, we don't have any instruction about filing agenda. If they file, then let's me pass an order and it should be hard final. Because my instruction on 10/5/2024. They are saying that it is filed on 12/5. After 2 days, my instruction.
The petitioner has filed a revision case number 22/13/2023/RC-1 before the Revisional Authority come Additional Secretary, which department?
Mines department. It is Ministry of Mines.
Ministry of Mines, correct.
In the Ministry of Mines, Government of India. Challenging an order of lapsing dated 27/2/2023 passed by the Additional Secretary to the Government of Odisha Steel and Mines Department. Full stop. The said revision application was filed under Rule 35 of
35 of
the minerals bracketed other than atomic and hydrocarbons, energy minerals bracket close concession rules 2016. Full stop. It is the petitioner's case. Where is the stay order?
Lord, that is at page 34.
It is the petitioner's case that annexure
Annexure 13 series at page 34.
that where is this stay?
No, but last, but third line. In view of the above, state government is asked not to take.
Page
Page 34.
Page 34.
Page 34, my lord.
By
Order dated
an order
23,
dated 23/2/2023,
24.
24. An order of stay
An interim order was
Interim order
passed
not taken.
requiring the state government not to take any coercive action till the next date. Stop. The matter was adjourned. Subsequently, the matter was adjourned to 23 to 2024.
Not adjourned to 12th of March 24, the last line.
23 adjourned to 12/3/2024.
Right, ma'am.
Stop. On 12/3, where is that order impugned?
That is at page 15, my lord.
In annexure?
Annexure 1.
Annexure 1.
Yes, ma'am. Annexure 1, page
On
15.
12/3/2024, the revisional authority vacated the withdrew the interim order earlier passed on the ground was seeking time to file rejoinder. Stop. The said order dated 12/3/2024 is under challenge in the present writ petition. So stop. Then senior counsel appearing on behalf of the petitioner has drawn our attention to Rule 36 of the rules and has submitted that the petitioner had a right to file a rejoinder to the reply filed on behalf of the state.
State.
On behalf of the state. So stop. The in such view of the matter, the learned additional secretary ought not to have held that that learned counsel for the petitioner was not ready to argue the matter only because he was making prayer, only because he was seeking time to file a rejoinder. So stop. Next. Section Rule 36 of the rules. We have heard Mr. So-and-so, the party. Stop. Rule 36 of the rules lays down the procedure for passing orders on an application for revision under Rule 35 thereof. So stop. It stipulates following stages, following steps, followed as 1. The copies of the revision application
shall be sent to the state government or other authority and to all impleaded parties, calling upon them to make comments as they may like to make. Next, the state government or other authority and the impleaded parties, comma, while furnishing comments to the central government, shall simultaneously endorse a copy of the comments to the other parties. 3. The comments received from any party under Sub-Rule 1 shall be sent to other parties for making such further comments as they may like to make within 1 month from the date of issue of the communication, and the parties making further comments shall send them to all the parties. Further comments को ये कर देना, hold कर देना. Full stop. A bare perusal of Sub-Rule 1 and Sub-Rule 2 of Rule 36 makes it clear that a party, that the petitioner being party to the revision, the petitioner being the revisionist had a right to make further comment after receiving the comments of the state government and other authority, the state government, in accordance with Rule 1 of Rule 36 of the rules. Sub-Rule 1. Sub-Rule 1 of Rule 36 of the rules. Full stop. We, after having carefully gone through, the order dated 12/3/2024, impugned order dated 12/3/2024, it is manifest that the interim order which was granted in favor of the petitioner was withdrawn for the sole reason that a time was that learned counsel for the petitioner had sought time for filing a rejoinder. To a rejoinder, that is further comments to the comments made by the state government under Sub-Rule 1 of Rule 36. Stop. In the court's opinion, comma, on that ground, comma, the additional secretary, the revisional authority ought not to have withdrawn the interim protection. Stop. The impugned order dated 12/3/2024, to the extent 12/3/2024 passed by the additional secretary cum revisional authority, deserves interference to the extent It relates to withdrawal of the interim order earlier passed on 23/2/2024. Full stop. Next. We have, however, been informed that the petitioner has filed his rejoinder, and the case is fixed.
My lord, on 12/5 there was there, thereafter I don't have any instruction. You may not find a way. Because they are saying that they are filed the rejoinder on 12/5. That was
12/5
fixed.
you filed your rejoinders.
That may be mentioned, Lordship,
File
because
is
they are undertaking
rejoinder.
that.
/ further comments. You call it further comments.
Right.
Further comments. Stop. List this. Further comments. Stop. In such view of the matter, comma, while setting aside the order dated impugn order dated 12/3/2024, to the extent as noted above, we observe that let the revision case, that is so and so RA 2215/2023 RC1, be disposed of expeditiously. Yes.
Yes. Let me clarify that no further adjustment can be taken in this.
We make it clear that the revisional authority shall be at liberty to pass appropriate orders if it finds any non-cooperation on the part of the revisionists in pursuing the matter before him.
Right. Now my friends will pay 2 sets of extra copies to be on the report.
2
Two
sets.
sets of extra copies.
We have 3 revisions.
Ah.
So it should pay 3 extra copies.
When I'll come in rest 2, then I'll pay.
3 instead of 3 years by 1. So it should pay lots of copy instead of lots.
But I'll offer a cup of coffee to my learned friend, so. So grateful.
Item number 62.
I beg apology, Your Lordship.
What for the officers are sitting here? Police officers?
It's my item 63. And my lord,
62, ma'am.
we did hire them.
All right. Yes.
62.
What happened? Complied
I beg apology, Your Lordship. There is, in fact, there is no delay. I wrongly filed the IA. IA had been not pressed, Your Lordship. There is no delay.
All right. I
The contempt application, Your Lordship.
withdrawn. Contempt.
Contempt.
Order complied with.
So it's same set of cases where what is different law. But applications are filed for enhanced compensation. There is some benefits. One officer who are there, they inquiry into the matter. In some cases, even though they are not entitled, not here, accounted the case, and so now it is.
Rightly.
State government, it was found that those are not so manipulated. So now we are reviewing that. Some time may be granted so that we can.
So where is the question of time? It has come for orders. It will come for admission later.
Yes, sir.
IA. So it has withdrawn.
For admission, item 63.
May please your lordship, this is a PAL matter, my lord. I am appearing for the petitioner in this case. This matter appears today's list as per order dated 8 May 2024 by order number 20. The relevant paragraphs of the said order are at para 2 and 3. I would like to place those paragraphs if your lordship permits.
Which order?
Order dated paragraph 2 and 3, my lord.
Yes.
I would like to place those paragraphs. Para 2. Pursuant to this court's order, Dr. Sudhanshu Sarangi, Director General Fire, was present in the court and he has filed a compliance affidavit online. Para 3. A copy of the said compliance affidavit be served upon the Law and Council for the petitioner tomorrow, that is on 9 May 2024. Released this matter on 15th May 2000. As per the said order and direction, the copy of the compliance affidavit has been served on the council appearing for the petitioner. And in reply, the petitioner has also filed the reply affidavit, which is dated 13th May 2024, which is at flag T of your lordship brief, my lord. And compliance affidavit is at flag C, flag S of your lordship brief. First of all, I would like to place para 3 of the compliance affidavit, my lord. Compliance affidavit dated 7th May, paragraph 3, my lord.
No, this is
Your
regarding
lordship,
what?
my lord.
My lord,
Ma-
it is not in my record. You have given it to SG office.
Hospital. Yeah, I remember.
That is already
I
there.
I remember.
That is matter relates to my installation
Yes,
of fire
We
safety,
remember, we remember.
my lord.
We are
So
trying. All
my-
of us are trying. He is also trying. The court is also trying. You are also trying.
we are trying.
So
with-
let us see what
let
has
us-
happened.
I have filed also reply affidavit to the compliance affidavit dated 7th May, which is
What have
at
you stated in your reply?
my lord.
What have you stated in your reply?
We have stated that some steps should be taken so that
They
matter
are
can be
taking steps.
expedited.
Sir, they see. We see no reason why the public servants shall not be interested in public interest also.
My lord,
Why shall they not act in public interest?
my lord.
So they are doing something.
They are doing, sir. Due to interference of this honorable court, my lord, the matter has been expedited.
So we
Only
are not
because-
interfering with their.
My lord, 2015 we have filed, my lord.
Yes.
Already they have consumed more
Those
than
buildings are very old buildings.
Huh?
There
It
may
may-
be some
it may-
difficulty in
my
putting
lord,
place.
we are obliged. It will take some
equipments
time, my
there.
lord.
See, there are two aspects.
My lord.
One, that this is an old building and this infrastructure will require a lot of investment also,
My lord.
apart from other difficulties which they may
My
be
lord.
facing. And secondly, they are coming out, I have been told, with a good hospital is
Yes, my
coming
lord,
out.
that is what I wanted. Now your lordship knows that a new hospital is being developed.
Our concern is
So far as the
that
old
is
building.
Old building.
Yes, his concern is also so far as the old.
old
existing-
building and something, if something happens tomorrow,
My
then
lord.
all of
That-
you
that
shall
is
be
the state I have also given in
I
my
have-
affidavit, the.
I am obliged, my
Director
lord.
of Police has given the affidavit. All the tenders have been floated and administrative approval has been given. So lordship may see para 3 and 4 of the affidavit of the Director General of Police.
Yes.
Para 3 of the compliance affidavit of the DG
Only
is at page 2. Para 3, my lord, of compliance affidavit. Dated
Yes, they
7th
are
May.
making all sincere efforts.
My
We are
lord.
very, we are satisfied rather with the steps taken by them.
My lord, we are also satisfied.
Uh,
But some reply we have given. We have given some reply.
uh, the Dr. Sudhanshu Sarangi, the Director General, Fire and Emergency Services, Commandant
Commandant General Home Guards
Service, Commandant General Home Guards
and Director Civil Defense.
and Director Civil Defense, Odisha is present in court. So stop. An affidavit has been filed by him disclosing the steps taken for installation of firefighting systems in all the buildings of SCB Medical Colleges, SCB Medical College and Hospital, Cuttack, including 14 projects as was noted in paragraph 5 of this court's order dated 13/3/2024.
24.
So stop. It has been stated that all administrative approvals as requested by the PWD authorities have been accorded by the competent authority and Health and Family Welfare Department and Finance Government of Odisha. First off, the tender process for installation of firefighting system in all the buildings, all such buildings
including 14 projects. They have been completed.
have been initiated by inviting tenders. Full stop. Next, it has, however, been stated that since the Model Code of Conduct for General Election 2024 is still in operation, comma, the tenders could not be opened on 16/3/2024. Full stop. A request has been made by the Chief Engineer bracketed Buildings, Odisha, request available? It has further been stated that the Chief Electoral Officer Odisha has been recorded to accord permission to open the bid by waiver of the said restriction, comma, through through a later wide number 18171 dated 19/4/2024. Full stop. The finalization of tender and execution of work will be taken up after getting permission from the Chief Electoral Officer Odisha or on the lifting or when the restrictions of Model Code Conduct are lifted on 4/6/2024. Full stop. Next. Since this matter is of immense public importance concerning lives of the persons undergoing treatment in one of the biggest hospitals of Odisha, comma, we observe that if you made this request on 19/4. All concerned with the hospital, comma, we observe that if no permission is granted by the Chief Electoral Officer Odisha as requested by letter dated 19/4/2024 by Friday, comma, the tender shall be opened under the orders of this court.
My lord, obliged.
So stop. List this case on Friday.
Financial assistance also be financial assistance for approve.
There, everything is happening.
My lord.
Inform us on Friday.
My lord.
We are keeping it on Friday at
My lord.
sorry, Monday.
Monday, my lord.
All right. On Monday.
Monday, my lord.
On Monday till Friday, if the approval is not given, we will pass judicial order for
My lord.
opening the tender.
Oblige, my lord.
Had we directed your personal attendance?
No, that
Sure.
was the learned advocate general was present on that day and he submitted
All right.
for your lordship that he will present on the lordship.
If you can join, instead of coming from, you come from Bhubaneswar, you are in Cuttack then, all right.
Online.
So you can join online also.
Online, yes. My lord, may I present on at 2 p.m. on Monday?
Monday 2 p.m.
Yes.
All right.
Monday to
In the meanwhile, you can tell the chief electoral officer
my lord.
that these matters should not be delayed.
Urgent matter.
Your lordship, for me, I will communicate this order to the chief electoral.
Yes,
Yes.
the order shall be uploaded today.
Your lordship, directly, that state council is directed to communicate.
Let this order be communicated to the chief electoral officer,
Odisha.
Odisha, by learned AGA forthwith.
My lord, copy of the order being communicated to the council.
This is-
Copy of the
this
order
will be
shall be
uploaded.
Will be uploaded.
My lord,
Every day you can get.
uploaded. Oblige me.
Even if I'm in the standing committee. Yes.
Item 64.
My lord, this is case of Anganwadi worker appointment.
It has come for orders, why? PIL matters, all PIL matters come for orders. Oh, this is for admission. Yes. Yes, what is your,
My lord, I was selected. I secured highest mark in the selection. I was selected and a appointment letter was also published in the office of the Sarpanch, local Sarpanch. But subsequently, the order was changed without any intimation, without any reason. Subsequently, now they have given in their counter that on the report of the local authorities, they have cancelled my appointment letter and changed the order. But in B4 of the counter, the date is mentioned as 17/2/23. My order was decided on in the year 2010. And
so you do not belong to that area,
yes, I belong to that area, my
That-
lord. I have given the certificate.
maybe.
I have given the certificate.
It's a
And
finding of
moreover,
fact.
the law is well settled by this by our High Court, Honorable High Court, that for this region area, the appointment cannot be cancelled.
Yes,
I'm filing this decision, my lord.
yes.
And in a similar matter,
What are you relying on? This order was passed when?
in
This order was passed when?
2007, man,
2007. And when did the scheme of Anganwadi came?
2010, my lord.
2010. So how
My-
this 2007 will apply?
My lord,
Anganwadi is a different scheme altogether.
in a similar matter, single judge decision is also there, my lord. Our High Court.
That will not bind us.
No, that is not binding, but for reference, I am filing. The candidate who was selected, he belongs to the same area, my lord.
So where is that? What is the finding? And report. Read by Pass it on. The petitioner, the appellant, has put to challenge an order dated 21/2020 passed by a single judge of this court in WPC number 21935 of 2016, rejecting her claim to be her or his to be engaged as Anganwadi worker for Patna Sahi, Patan, Patna Sahi ward number 10 Anganwadi Center
Tangi block.
in
District
Tangi block of district Khurda. Stop. While rejecting the appellant's claim, learned single judge has noted the fact that the appellant did not belong to Anganwadi center area and therefore her candidature was rightly not taken into account, though she had secured highest marks and satisfied the eligibility criteria. Stop. Next, learned counsel appearing on behalf of the petitioner has relied on a division bench decision of this court in case of Chandramani Jaina versus State of Odisha, reported in 2007 volume 2 OLR 577 to submit that on the ground of residence criteria, the appellant's claim could not have been rejected. Full stop. Next. The said submission is not tenable for the reason that in the matter before this court in case of Chandramani Jaina, clause 4.1 of the advertisement was under challenge, of an advertisement was under challenge as illegal, discriminatory and unconstitutional, being violative of Articles 14 and 16 of the Constitution of India. Full stop. It is not in dispute that under, what is that called, Anganwadi scheme? What is that scheme called? related to appointment to the post of Swechasevi Shikshak Shikya Sahayak. Full stop. The scheme. What is that Anganwadi scheme called? What is that called? Ah. The selection of Anganwadi workers is governed by the guidelines for Anganwadi workers issued by the government of Odisha, Women and Children Development Department. Full stop. No provision of the said guideline is under challenge. Full stop. The petitioner had rather participated in the process of selection, knowing well the scheme of Anganwadi. Full stop. It was specifically stipulated in the advertisement that a candidate must be a resident of Anganwadi center area. Full stop.
My lord, one thing I want to
The-
point out. Here, as per their circular at page 8 of the counter filed by the government, it is mentioned village public Anganwadi center. So I belong to the same village as the other candidate who was selected, she belongs to the village.
Yes, what is your?
My lord, at page 8 of their
Just a minute,
counter.
just-
Application for selection of quality workers involves the government public Anganwadi center area from original deciding the state village and 5 deciding statement in a village there are 2 Anganwadi centers. If that Anganwadi those who belong to particular Anganwadi center, they are differently correct. This is the guideline.
No, he is saying other village. No. Where is the advertisement?
My lord, as per the advertisement, at page 14 of my writ appeal file.
Yes, what is there?
It is, there were 3 candidates.
Mister, what was there in the advertisement?
Advertisement
What
was
was the requirement, whether Anganwadi area or village?
Anganwadi village, my lord. There was no specific condition.
Was
I
there
don't
any
know.
advertisement issued?
Yes, my lord. But at present, I don't have that.
That's not the definitely the case to be
Yes.
to the select list. Advertisement is not. I mean,
How can we decide? In the absence of advertisement, how can we decide?
My lord, I have one copy.
What advertisement is there? That we cannot see. This is not the way. Can See what is there in the advertisement, read it.
ଏତଦ୍ୱାରା ଟାଙ୍ଗୀ ବ୍ଲକ ଅଧୀନରେ ଥିବା ସମସ୍ତ ଗ୍ରାମ
Please read
ପଞ୍ଚାୟତ
the eligibility condition. Brother. You say that in Odia. Yes, eligibility.
eligibility matriculation English I have not brought that English translation, my lord.
That's not the advertisement in that description. Another description of time. There is the advertisement. That's not the application that I'm reading in English. That the candidate, those candidates who have applied for the Anganwadi center must belong to that village public hamlet public house numbers within that center area.
So either.
Is my lord,
That was the position then. And you
but in that guideline, in that guideline, the filter area is there. But not the same that guideline, may I read again that guideline. It's the application for what the for each
either village or.
that part, another clarification was issued. That was issued on 1/3/2008. According to paragraph was revised and looking at that is the base 50. Locksmith page 52. That means that 1/3/2008. Page 54.
54.
Of that. What is the only use?
Yes. Yes.
According to paragraph 1 of the event guidelines, Anganwadi workers should be resident of the AWC area. If no suitable candidate is developed in the AWC area, then candidate of the village should be considered.
Where is that order?
That is the.
Oh no, some judgment is there. All right, tomorrow we will pass.
Mr. Patnaik, in your case, we have decided in division bench. In your case, Mr. Santosh Patnaik was appearing.
That was board number 3 also part of that bench.
No. After that, Mr. Santosh Patnaik, senior advocate, was appearing. I recollect, yes. Anganwadi center, this particular 2008 circular I have referred to.
Tomorrow.
And the center area.
Item 65. Yes.
May I please, Your Lordship. Lordship has heard this matter yesterday.
Yes.
That Lordship,
Please.
page 14 my lord, the input order my lord. Lordship has asked me why, when the direction was given to reconsider each case, why this appeal was filed. Lordship, see paragraph 9 of that order.
Yes.
Honorable single judge has held that if the petition is admittedly senior to those 35 number of employees who have been re-engaged in the year 2008, and our case is that none of his junior has been regularized on the ground that this was the division wise. And
You could have reconsidered and you could have passed the order.
Yes, my lord. We have, in fact, we have reconsidered and passed the order. And after that, accordingly, we reconsidered and rejected his case because none of his junior has been regularized. After that, my lord, he filed a contempt petition, and I am giving the 3 dates. In that contempt petition, annexing that rejection order, that we have not complied this order. Because the direction was, as 35 juniors have been regularized. I am clarifying that 35 juniors, that admitted fact 35 juniors of other division. We cannot take into account those juniors.
You could have sought review of this order.
That was the case before the honorable, that you may draw my lord's notice to the counter, my lord. Counter and his rejoinder. In his rejoinder, he has also admitted that none of his junior of that division where he was working has been regularized. He has said juniors of a Prachi division, that is separate division. It is his case, he has admitted in his rejoinder. May I draw my lord's notice to the counter and rejoinder, only 2 paragraphs, my lord. May I draw my lord's notice to that counter, my lord? And also 1 paragraph of his rejoinder, and it is his document, my lord. Let's see the rejoinder filed before the honorable single judge. My lord, got it?
Yes.
My lord, you will see paragraph 4 of the rejoinder. Paragraph 4, the applicant was initially appointed in the year 1996. On 7 to 2018, similar citizens who were admittedly junior to the applicants was brought over to work without considering the applicant. Then the next sentence, those 18 employees were continuing under Prachi division. It was this, so and so. When similar situated person junior to the applicant belonged to Prachi division, he belongs to Marsaghai division, and it is not his case that juniors of the Marsaghai division has been brought over to the regular establishment. So your lordship asked him that to clarify that when this is the position, my lord. Even if other juniors of other division has been, and I am showing that document, your lordship may see that another document he has filed, that in some divisions on the basis of their engagement, on the basis of vacancy, even if those who are appointed much after him, 1-2 years after him, they have been regularized. There is no dispute to that. But where he was appointed and he was disengaged in the year 2003 and got the compensation benefit after his disengagement, he approached my lords in 2014. And it is not his case, any of his junior of his division has been regularized. And I want to bring one document, my lord's notice. Your lordship may say that all these documents are that has been filed by him. Your Lordship may see that one document at annexure 17
Is
of
there any decision on this point that the seniority list, combined seniority list is
there is
there?
no, my lord, but that I have to, if he is to get relief to that extent, a combined seniority, then I don't stand on the way, on his way for regularization. But
So is there any,
I'll verify that.
how do we? How with single records that's admitted? No, it's admittedly 35%. Senior, junior. Admittedly 35%. How do you say? How do you respond to that?
Is there no scope for transfer or shifting of
No,
workers from
For that-
one division to
for
another?
that reason, I am showing one document he has filed. For that reason, Your Lordship, annexure 17, it is marked to his regender.
No, never it happened that
By that, I will take
certain
instruction
persons-
because
certain
if-
persons got
my lord, I understand.
deputed from
If
that division
there
to
is
this
a-
division.
Yes, Mal, if there is a common gradation list of retained employees, then any of junior is regularized, he has a case. And it is not the case that there was a common gradation list. And Lordship will permit me sometime, I will take instruction whether there was any common gradation list and any of his junior from that common gradation list has been regularized.
Yes, what is your stand?
My lord, for different divisions, one common gradation list is being prepared. One EIC is there, engineer in chief. That annexure 19 of my regender manual, right to information I have obtained, it has been reported by the letter under reference.
See, I don't rely on Right to Information Act.
My lord,
So you cannot develop your case on the information which you received under the Right to Information.
Chairman, in
Huh?
that regender, another judgment I have relied that in similarly situated person, he has been considered in another division my lord. There my lord, it has been discussed, the lordship, and you have a glance, page 15 of my agenda, it has been my lord in para 6, and I am placing with the lordship's permission.
So this is being done under any scheme or
My lord,
is there any scheme?
for different divisions, one EIC is there, he considers the gradation.
Still,
of the-
for different districts, there is one secretariat
Yes,
in Odisha,
yes.
in Bhubaneswar.
Right.
So that will not determine that all service and everything is unified.
Well,
So you tell us whether there was any combined, we cannot call it cadre, but there was some combined seniority list or something.
Hey, Your Lordship, may permit, give me some more time, I will take instruction on that. On his behalf, I can take instruction from the government.
para 6 and permitted placement. And it has been stated, considering the respective cases of the party as made out before the tribunal upon hearing the parties who adding both oral and documentary evidence came to conclusion. In the input award, as already mentioned, during course of the hearing of the petitions and affidavit were filed on behalf of the NMR employees, union representing workmen in WTC.
Now you are reading industrial dispute.
Yes.
A minor. These persons had ventilated their grievances for the industrial dispute. Tribunal. The tribunal allowed the petition and directed the government to continue them, to regularize them. Thereafter, a state came before the honorable court. That petition was dismissed. Thereafter, state went to SLP. SLP was dismissed. But now state is taking a plea that that order is only applicable to that case only. That petitioner in that case only, not to other persons, not to the present petitioner. Here,
All right, let us see, take instruction.
Yes, my lord. As some more time may be given, my lord, because
Requested on behalf of the applicant, list this further on. After vacation. mention in the morning. Okay, well.
Item number 70.
Yes,
Item.
my lord, in item 70, I just want to press my an amendment petition, my lord. Some documents which I received after filing the case and after filing the counter, my lord, I want to bring it to my original record, and I also want to amend my prayer to cast the same, my lord. I have given the schedule of amendment. So if that will be allowed, I will file my consultative application by Friday, and the matter may be listed for admission immediately after vacation, my lord.
Which is the IA?
IA 4563 of 24.
Have you seen? Please give him a copy. Give him a copy.
Extra copy.
Give him. May take up tomorrow.
Item 6.
No, only those documents they have filed. I want to bring it to the original record. That is, and I received through RTI. That is the only prayer, my lord. If that will be, if in consolidated petition also, I will have to amend those things, my lord. If this petition will be allowed, then by Friday I can.
We will have to stop this practice.
Yes, my lord.
Of entertaining documents which you obtain under the Right to Information Act. So that is a different procedure altogether. And information supplied by the the public information officer is subject to challenge.
Yes, my lord.
Can be challenged.
That is why. Yes, my lord. That is to be challenged.
Then-
that is being to bring. I have filed it on
Then
affidavit.
why should we rely on
Your lord
such?
may say,
You will have to you will have to find yourself or the court.
I have-
They will bring on record. Or you
I
may say that this is the document which is there. We may direct for them to produce a document.
Yes,
But
my lord.
not on the basis
Your
of
lordship
the
has directed
information
them.
which you receive.
Your lordships have directed them to produce that judgment filed in the lease case. They have filed it, and I want to challenge. I want to
We will
bring it
see
to
tomorrow. Give him a copy. He has right to.
Okay, okay. No, I have already. Okay, tomorrow I will give him the copy. Because
Item
item
66. Item 66, next item. We will take it up tomorrow.
Please wait. Serially.
Item 66.
66.
Item number 66.
Yes.
And I will propose it tomorrow. May I pray, my lord, your lordship, call this matter tomorrow. 66, my lord, senior is appearing here.
This matter on mention the matter has come. This matter is urgent because the
Tomorrow, I am praying for tomorrow.
tomorrow 2 p.m. Tomorrow 2 p.m. Just 2 p.m.
Tomorrow it will come, not 2 p.m.
Item 67.
Item 67, my lord, the transport matter, it's notification in as per scrap policy. So can it be on Monday at 2 p.m.? Because
What is this
or
about?
after
Is a
vacation,
additional fee, my lord, under the Motor Vehicle Act.
Motor
additional
Vehicle Act,
fee has been
yes.
levied. That
a
is
lot of cases, about 56 cases has been listed. So
Last
if
occasion,
if
your lordship.
it's after vacation also, it's fine.
Thereafter, another notification has come.
Yes, yes.
Yes.
Your lordship is right, my lord. Your
There
lordship.
are three notifications,
No,
16,
no, no.
70 and 21.
Yes, the three
You should
notifications.
take it conjointly and lordship may pass order. So can it be after vacation? It is better, man.
Your lordship.
Why after vacation we can have time to write judgment?
My lord. Your lordship.
Monday?
Monday, your lordship.
Tomorrow
Your
and day
lordship
after.
had the matter and reserved for judgment. Your lordship passed the order.
Man, tomorrow and day after I have some difficulty. Monday, Tuesday, any day it is. Tuesday, it's Monday.
Tuesday to
Tuesday.
Additional fees.
Monday is better.
So they have not.
Monday,
So they have complied. Then they have brought out another notification, invoking another provision. So they are saying that in that provision, they have the competence to. That is now challenged.
And our High Court judgment is very clear, man.
So we'll hear it tomorrow.
Well,
Mr.
Man, tomorrow and day after I have some difficulty, my lord. Can it be Monday?
Monday.
Monday, yes, ma'am.
Your lordship.
At 2 p.m., my lords, this case may be on Monday, my lord.
No.
2 p.m. matters are fixed.
Fixed.
You can take up.
Yes, my lord. My lord, take up.
Your lordship's convenience, your lordship will take.
Item 68.
Till.
In this case, 68.
No, 69.
Oh, sorry.
May I please your lordship? The petitioner challenged the Honorable Single Judge Order Mirror at Annexure 10, page 29 mirror. By the order of the original the petitioner mirror, in the writ petition was listed on 28/9/2022 mirror.
No, where is the order?
Order mirror page 24, Annexure 7.
Then you can seek review.
Yes, your lordship, it can be only. Actually, I filed an application to recall that order mirror because the list was pending mirror. Because by that time, the advocate appearing for
Mr.
the
Counsel, this is an order passed by a learned single judge
My
of
lord.
this court. If this is the order which has been passed, then you can seek review. Why? How can you maintain this?
I have asked for the recall of the order mirror.
Yes.
Then and by Annexure 10, it was in dismissed mirror.
So
Page 29, Annexure 10 mirror.
again, you committed the same mistake. You file an interlocutory application.
My lord.
You should have filed a review. How your application could be maintained?
And in this case, my lord, when the matter was listed, my lord, the advocate appearing for the petitioner, he has died in prematurely.
All right,
For
file
that
a
reason-
review application.
Yes, my lord. For that reason, it could not be brought to the knowledge of the court, my lord, that the list is still sub judice pending, my lord, because after that, similarly matter has been disposed of. I have annexed that order, my lord, had Annexure 8 and the petition of that petition has got benefit. For that reason,
The appellant had filed. Forgot. WPC bracketed OAC number 145 of 2019 was dismissed by was disposed of by an order dated 28/9/2022, which reads as under the said full stop. The said order dated 28/9/2022 reads as under. Stop. It is the case of the appellant that the case had in fact not become infructuous and the cause of action was surviving on the said date. So stop. Instead of seeking a review, appellant filed an interlocutory application in the disposed of matter seeking recall of the said order dated 28/9/2022, passed in WP OAC number 145 of 2019. So stop. By filing IA number 200 of 2023, which has been dismissed by an order dated 17/11/2023 by a learned single judge in following terms. Quote kar do. Stop. By filing present intra-court appeal, the appellant has put to challenge the aforesaid two orders. So stop. Next, learned counsel appearing on behalf of the petitioner has submitted, the appellant has submitted that the counsel representing the appellant had died
In the read petition has died.
When WPC number so and so, WPC OAC number 145 of 2019 was taken up by this court on 28/9/2022. So stop. Next. Be that as it may, we are not inclined to interfere in the present inter-court appeal with the impugned orders passed by the learned single judge. So stop. We, however, make it clear that the appellant shall be at liberty to file a review application seeking review of the order dated 28/9/2022 on the grounds which may be available to him. But you will have to demonstrate
My lord,
that the person in your review application, that the lawyer had died,
my lord,
no one was appearing.
my lord.
So these things,
That I have-
otherwise, how can we say that that was wrongly, incorrectly recorded? Some lawyer was appearing. So was he an imposter?
So some government council must have stated so.
No, he must have appeared, Mr. Kutia.
No, they have somebody else. No, yeah, High Court.
59, my lord.
75, it is already complied by document.
75
Next,
75 million complied.
compliant.
next item, my lord. This is relating to the land acquisition matter related to scheduled tribe candidate. Scheduled
75.
tribe.
What do you want?
Maybe taken
Proceed, Rob.
tomorrow at 2 p.m. my lord.
Which matter?
It is a public interest litigation and matter has not been taken up for that reason.
I am
waiting for
appearing for the
3
QP
weeks,
number
it is in the
5
list.
and I have
But-
filed the counter and
My lord,
discuss as well just.
Intentionally he is prolonging the matter
No, no,
and
interest,
without
the
paying any
counter,
compensation and other
the
benefit.
counter, I have filed the counter
My lord,
on
maybe
13th
taken.
and I am
I am not
serving.
accustomed to this situation where two lawyers speak together.
But I am the petitioner in this case, maybe taken tomorrow after 2 p.m.
We cannot guarantee.
My lord,
We cannot guarantee that because tomorrow at 2 p.m. matters
my
are
lord,
fixed.
since 3 weeks I am voting. I am on the yesterday,
Blame
on
your
the first hour I made a mention.
blame
Take up the matter.
blame the pace of your chief justice. What
My
you
lord,
can-
May I,
May I try to estimate take up on the sorry. Reopening.
No.
Mr. Counsel,
It is
what is this?
Urgent matter, my lord.
There is no urgency in this.
Yes, urgent is there because they have filed a.
Just a minute,
They have filed a counter in the stating that they have
What is
paid the
PIL
compensation.
about?